The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court. For our first case today, we're going to have case number 20-7382, DeLundy Coleman versus Sergeant Jones.
Thank you, Madam Clerk. Welcome, counsel, to the Fourth Circuit today, this remote situation. And we have Mr. Ballinger with the University of Virginia going to introduce the student counsel. Is that right, Mr. Ballinger?
Yes, thank you, Your Honor. May it please the court. I'm the director of the... either one, Your Honor. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce Mr. Barrett Anderson and Mr. Timothy Shriver, who will be presenting argument for Mr. Coleman.
Thank you, Professor Ballinger, and it's great to have you all do this good work for us, and Mr. Anderson, it's good to have you with us, and you may proceed.
Thank you, Your Honors, and may it please the court. The district court's grant of summary judgment should be reversed for 3 reasons. Qualified immunity for intentional discrimination. Second, forcing Mr. Coleman to choose between his religious beliefs and a diet that contains meat is coercive and a substantial burden on his free exercise of religion. Clearly established law demands a penological justification for such coercion, and here there was none. Finally, Mr. Coleman has a triable case under the Establishment Clause because the defendants treated Jewish inmates favorably to Muslim inmates. Now, the district court's most straightforward error was granting summary judgment on qualified immunity bases while simultaneously recognizing that this record supports a reasonable inference of intentional discrimination. The Supreme Court in Crawford L. and this court most
Don't we view qualified immunity from an objective lens?
Your Honor, in Thompson versus Commonwealth of Virginia and Dean versus Jones, this court held that when the constitutional violation turns on the officer's subjective state of mind, like it does for equal protection violations, there cannot possibly be qualified immunity when the officer acts with a culpable state of mind. So
there's no place in qualified immunity in this context for an objective viewpoint? We don't look objectively to whether the violation was clearly established?
Not under intentional discrimination and equal protection, Your Honor. Because when an officer acts with a culpable state of mind.
What case is that again?
This comes from the Supreme Court's decision in Crawford L. and also this circuit's decisions in Dean versus Jones and Thompson versus Commonwealth of Virginia. In both of these cases, this court denied qualified immunity because the officers acted with a culpable state of mind.
With a
counsel?
what? Oh.
No, sorry.
Go ahead.
He said culpable. Counsel,
right.
Does some of this turn, I mean, I understand what you're saying, and the district court did find that the record would support a finding of intentional discrimination. Is that what he said? Yeah, intentional discrimination. But does some of this turn on what we mean by that? Like the fact that you intentionally treat people differently isn't necessarily unconstitutional, right? Like we had a case about whether a ban on women sunbathing topless on a beach violated the Equal Protection Clause. No question that the officials were intentionally treating men differently than women, but I don't think we would have said it was clearly established that to do so violated the Equal Protection Clause. So does part of this turn on what we mean by intentionally discriminate?
Yes, Your Honor, and in this case, the district court in its discussion of equal protection specifically pointed out that Muslims were treated inferior to other religious groups within the prison. It means that it's because he is being treated differently due to his religion, and he's being treated inferior to other prisoners. And so this intentional discrimination claim and the finding from the district court specifically precludes qualified immunity, especially on summary judgment at this point. However, if we even setting aside the intentional discrimination argument, Mr. Coleman has a tribal case that his free exercise rights were violated under his clearly established free exercise rights were violated because the defendant's substantially burdened.
The meal he was provided was compliant with his religion, correct?
No, Your Honor, because he is consistently maintained, and the district court erred in finding that he had waived his claim.
How would the well, go ahead, finish your sentence.
I was just going to say, because he has consistently maintained that his religion requires that he eat meat, and this is supported by expert testimony.
When did he maintain that in front of the prison authorities? The thing about the religion requiring meat didn't come about until the lawsuit was filed, did it?
Yes, Your Honor, but in his initial complaint, he did point to several Quranic verses indicating.
So when you said yes, Your Honor, you're agreeing with me that the meat, the requirement that he eat meat, that allegation did not come about until after the lawsuit, correct?
Correct, Your Honor.
I'm
that
correct.
Allegation.
So then I go back to how it was.
You're agreeing with that with Judge Thacker's statement there? Yep. The meat issue only came up, or contention only came up when the lawsuit was filed?
I believe so, Your Honor. In his initial complaint, he did point to the same Quranic verses that he claims support his belief that he is required to eat meat. However, the explicit...
That creates a lot of problems for you, doesn't it? That he didn't bring it up? How do you get around that?
Yes, Your Honor, but they have not argued that he failed to exhaust his prison grievance. They've not argued...
No, this goes to the qualified immunity. And whether it even goes to your argument that they intentionally violated some constitutional right of his. I don't understand how they could have intentionally done that when they were providing him a Muslim compliant meal based on what their procedures said and what the facility that provided the meal said. And all he told them was that he was not getting enough to eat. That sounds more like I'm hungry.
Yes, Your Honors, but if the defendants want to challenge the sincerity of Mr. Coleman's religious beliefs, then they can.
No, I'm not, I don't think anybody's questioning the sincerity of his religious beliefs. What I'm trying to understand is where in the record is the indication that the correctional facility intentionally violated any of his constitutional rights based on his sincerely held religious beliefs.
Yes, Your Honor. Even if his religious beliefs did not require him to eat meat, there is still the coercion that it placed on him when the prison forces him to choose between his religious beliefs and a meat-based diet. This course of pressure... Counsel,
sorry, it's Judge Harris. I understand your argument about being forced to choose between a religiously compliant meal and a meal with meat. But I am not even, I guess I don't understand. It seems to me there's a more fundamental problem here, and this is also, something I will ask your colleague. The district, everybody seems to agree that under clearly established law, your client was entitled to a religiously compliant meal that was nutritionally adequate. The district court found that there is a significant dispute of fact as to whether the meals he was given were nutritionally adequate or not. If they weren't, I don't even understand the defendants to be arguing that that would not violate clearly established law. So why do you need this argument about being coerced to give up meat when the district court said there's a dispute of fact as to whether these halal meals were nutritionally adequate or whether they caused him very severe physical problems? Why? I'm not understanding the breadth of your argument given the district court's finding on that kind of core question.
We agree that finding on that core question should have precluded summary judgment and this should have gone to a trial.
They precluded summary judgment. He ruled that you would have had a right to a trial on the first part of the thing. That is, there was a constitutional violation. He said it wasn't clearly established. And they had qualified immunity. The constitutional violation, but there's no cross appeal here. You won on what Judge Tringer ruled as to their failure to give him the right meal. I thought he ruled in your favor.
No, Your Honor, the Judge Strenga dismissed.
Claim to qualified, but he said they're entitled to qualified immunity, and that's
Correct.
and that's right.
No, so we disagree that the defendants were.
Won the first half of the case. I thought they lost the second half of the case.
Yes, Your Honor, but
appealing the second.
We are appealing the second part of the case. We're appealing the grant of qualified immunity, or the finding of qualified immunity.
The issue on appeal, but Judge Stringer ruled in your favor on the first part of the case, and they didn't cross appeal. They have not crossed appeal.
Yes, Your Honor, but we do believe that the district court erred when it defined the right as the right to eat meat in prison, and that's not how this analysis necessarily works under Turner.
You're saying he's defined the right as he mystified the right as overly narrowly. You want a broader right.
Correct, Your Honor.
A narrow right.
Correct, Your Honor. We believe under Turner and this court's precedents in Thompson, in Lovelace versus Lee and Wall versus Wade, that the clearly established right is the right to a religious accommodation absent a valid penological justification. And here, there was no valid penological justification. The defendants have pointed to several very abstract, very speculative penological justifications. However, as the district court found under this record, their vague administrative concerns.
He ruled in your favor on that point, and they haven't challenged it, right? On that Turner point, Judge Stringer ruled in your favor. They don't challenge that on appeal.
We would agree with that, Your Honor. However, the fact that the fact that qualified immunity was still granted is problematic in this case because it left Mr. Coleman remedyless. When a officer violates a constitutional right but then receives qualified immunity, they have to come up with a valid and reasonable penological justification, which is absent in this case. And in this case, the defendants have pointed to several vague administrative concerns. It's true. However, Judge Strenga found that these were belied by the record. And we would point this court to specifically several different, one statement from Wall versus Wade, where this court said that generalized rights or generalized claims of penological justification are not sufficient in this instance. And so if the defendants are going to claim that they have a valid penological justification, if they're going to claim that they are not liable for violating Mr. Coleman.
Can we go back to Judge Harris's question about not being nutritionally? I'm sorry, Judge Harris. What you can phrase it better than I can, but I don't think I got an answer to that question. Did you, Judge Harris?
No, I don't. And again, I don't want to tell you how to argue your case, but as I understand it, there is no dispute in this case that there is a clearly established right to a nutritionally adequate, religiously compliant meal. The district court found that there is a dispute of fact as to whether your client was given such a meal. And so I don't understand why you need to be arguing that the clearly established right should be viewed more broadly than the one I just said. You get a right to a religiously compliant meal that will keep you healthy. And the district court said there is a significant dispute of fact as to whether your client ever got such a meal. So I guess this is a genuine question. I'm really not trying to tell you how to argue. Am I missing something that makes this case more complicated than it seems to me? And if so, what is it?
No, Your Honor, we don't believe you are. We believe that Mr. Coleman has a tribal case, that he was suffering significant health consequences, and every court that has ruled on this issue has found that significant health consequences are a substantial burden, and that dispute of fact, we believe, should remand this.
As to his health consequences, what did the prison know at the time about the alleged health consequences? I thought those also came about after he went to another facility after the litigation.
I may have to check the record on that, Your Honor, but my understanding is that he number one, was monitored multiple times during his cell watch, and that he visited the infirmary multiple times, And in every one of those visits, he complained about well, not in every one, but in several that are unredacted. In several of them, he specifically complained about the gastrointestinal issues that he was suffering, his weight loss, and he blamed it on the diet. Now, assuming these facts is true at this stage of the litigation, as we must, Mr. Coleman has a triable case that he did suffer these significant health consequences, which would require that this case be remanded for trial. I briefly want to point out that we, in our brief, argue that Mr. Coleman has a triable case that the Establishment Clause was violated here because the defendants treated Jewish inmates more favorably than Muslim inmates. And under Cutter versus Wilkinson, the Supreme Court has demanded neutrality in treatment between religions. And in this case, the defendants have pointed to no discernible secular purpose for treating Muslim inmates inferior to Jewish inmates. The district court recognized in its opinion that the defendants could have just shifted to dual certified meals, which they've served in the past in the prison, and this would have fixed the entire problem. However, they've refused to do so. If your honors don't have any other questions, I'd like to reserve the remainder of my time for rebuttal. Thank you.
Let me see. Mr. Kreiner?
Thank you, Your Honor.
You're representing the defendants, are you?
Yes, sir. I'm representing Sergeant Jones and Major Johnson.
Good to have you with us.
Thank you, Your Honor. If I could begin, and I think Judge King hit a lot of this in the questions he was asking my colleague there, but the single issue before the court is the grant of summary judgment on the basis of qualified immunity. As the court, as Judge King was referencing, prior to that aspect of the ruling, that's the only adverse ruling that plaintiff received on summary judgment. Summary judgment was granted on that single basis. If the court recalls, prior to getting to the district court, many of the issues have become moot regarding injunctive relief, declaratory relief, leaving us only with civil damages against Sergeant Jones and Major Johnson, these government officials. And as the court is aware via the U.S. Supreme Court, when you're looking at civil damages for government officials performing functions, their discretionary functions, you're looking at Harlow. And I think that's why the court asked the questions regarding whether the right was clearly established to a diet with meat that satisfies the law, because that's the language in Harlow. That
counsel,
you're shielded from, yes.
Counsel, sorry,
Yes.
Totally, I understand your argument and I appreciate it. You are not disputing, right, that there's a clearly established right to a religiously compliant meal that is nutritionally adequate, right?
We are not. And to answer the court.
And you don't dispute, I assume, that the district court found that there was a question of fact as to whether or not the plaintiff here received such a meal.
No, we're not disputing that. That was
then how can we grant summary? Then how can there be summary judgment on qualified immunity? I don't understand it. There's a clearly established right to a nutritionally adequate, religiously compliant meal. The district court found, and you don't contest this anywhere in your brief, that there is a significant factual dispute as to whether or not he received halal meals that were nutritionally adequate. He alleges that he told people, I'm not getting enough calories, that's why I'm sick. How can we grant summary judgment on qualified immunity then? I don't understand.
Well, Your Honor, remember, we're talking about the objective reasonableness of the officials at the time. And he didn't raise these issues at the time that he wasn't getting nutritionally adequate.
Why didn't you file a cross appeal?
He says he did.
Mr. Crider. You didn't cross appeal.
Well, if the court, I'm sorry.
I said you did not cross appeal.
We did not. We were granted on the basis of qualified immunity, and we feel that's the only issue. I'm sorry.
So you accept the adverse ruling made by Judge Tringa
for
the purpose of this case.
If the court recalls from the record in the bids and the contracts that were presented to the court and that are part of the record, each of the meals contains each of the meals in the bid are required to have the same amount of calories, regardless of what they are. So whether it's religious, common fare, bagged meals, the number of calories is supposed to be the same provided by the vendor. And so again, we're looking at the reasonable person in the official's position with knowledge that all these meals are supposed to be the same nutritionally. And then they're just
I mean, that may
instructed on
be,
that
counsel, but the district court did find that there's a significant dispute of fact as to whether he had physical health issues that were caused by not letting him have something more than this halal meal. And so, you know, you not only did you not appeal that finding, you don't argue about it in your brief. I guess I will just ask the same question. I feel like maybe I'm missing something about this case. Is there a complication here that I am missing?
No, Your Honor. The crux of the law, as we've gone through the other circuits, is not that we can see that there's a requirement that it be nutritionally adequate, but the crux of the law is that vegetarian meals are nutritionally adequate. And so we can talk about that being an issue.
And that's what you said
fact.
in the district court. And the district court said the defendants argue that the vegetarian meals were nutritionally adequate, but the plaintiff asserts that those meals caused him to lose weight, suggesting that they may not have been adequate. Moreover, extreme health effects are not necessary to demonstrate a substantial burden. That's how he finds the dispute of fact. He understands that your position is that they were nutritionally adequate, but he thinks on this record, that's a jury question.
Well, Your Honor, I think the court finds for the plaintiff on that matter and then grants us summary judgment on qualified immunity on another matter.
Right, and I guess I'm saying that looks like a legal mistake to me, given the finding about the factual question as to whether the meals were nutritionally adequate. I think it may have been in error to grant qualified immunity.
Well, the court has to remember we're talking about two parts here in the analysis of qualified immunity. Part one is whether there's a clearly established
you lost
right.
on one of them, and
part,
you won.
I'm sorry.
You lost on one, and you won on the other.
Right. Part two is whether a reasonable
if the law
person,
is clearly established, there has to be a trial. Isn't that right?
Well, Your Honor, the second part regarding qualified immunity is rights of which a reasonable person would have known. So you have two prongs here, a clearly established right and a right that would have been reasonably known. And you have to remember we're looking at Sergeant Jones and Major Johnson, two low-level supervisory positions here. These aren't policymakers.
You're trying to argue a subjective argument now.
No, Your Honor, it's still an objective test. It's still an objective test, but it's a person in the official's position.
Whether the law is clearly established. And if the law is clearly established on the point at issue, then the district court erred. And he's already ruled that there's disputes of fact that would warrant a trial. Otherwise.
Well, no, Your Honor, I think what we're doing is we are separating out qualified immunity when both are required. So the general rule under Harlow is that the officials are going to be shielded from liability. So that's where you start. The shield starts there when it's civil damages against a government official, insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And we're getting hung up before the word of right there. And if you look at the district court's decision.
All I see that the officers knew as to whether this was nutritionally compliant at the time that he was complaining while he was in jail was that he said he wasn't getting enough to eat. That is what they knew. Is that enough to make it clearly established? Because the health issues and him losing all this weight and saying he lost all this weight and having all these stomach pains occurred in the interrogatories after the lawsuit was filed, right? So is him saying, I'm not getting enough to eat, in your view, sufficient to for it to be clearly established for the officers at the time such that they should not get qualified immunity?
No, Your Honor. And if you recall, and the district court notes this, part of the dispute is that Mr. Coleman had engaged in multiple hunger strikes during this time and during his incarceration there. So the district court notes that in its in its analysis. And then when the district court actually gets to its decision where it grants us qualified immunity, it actually kind of flips it and goes to that second prong that I'm talking about, saying that the Sergeant Jones, Major Johnson, and an objective standard could not have known that their actions of giving him the halal meal as basically instructed would violate his constitutional rights, even with
Counsel, that's not what the judge said. That's not what the judge said. The judge said the reason they get qualified immunity is that there is no clearly established right to be given meals with meat. That's what he said. He did not say there's a mismatch between what he thought had to be clearly established. I don't want to personalize this. The district court thought that there could be no qualified immunity unless there was a clearly established right to be given meals with meat. And I am suggesting that that looks to me like a legal error. There is a clearly established right to be given nutritionally adequate meals. He had already found there was a jury question on that point, and he did not deny qualified immunity because he thought that the guards were not on notice as to the nutritional problem here. The denial of qualified immunity was because there was no clearly established right to be given meals with meat. It's just a non sequitur.
And that's what you argue in your brief, Mr. Kreiner. As I recall, I think you have a section that's called that. There's no constitutional right to get meals with meat.
That is correct, Your Honor. But remember, when you're applying qualified immunity,
you're arguing on appeal. There's no such constitutional rights, you say.
Well, there is no such constitutional right to meat, and that's why we went outside the circuit so much, because we searched high and low to find a scenario in which plaintiff was granted the relief plaintiff is requesting, which is a non-vegetarian meal because of his religious election. And we went through the 3rd, 2nd, 6th, 5th, and 8th, and all of them said no. And so we have a similar scenario in each of these circuits, and it causes one to ask, what is different here in our circuit that we would be correct where so many of the other circuits have been wrong. Even in looking in the district courts within our own circuit, they have actually ruled that a meat-free diet available under Islamic law as an alternative does not require an inmate to choose between his religion, and that it's nutritionally equivalent. That's the Turner Bay case. And so I understand the court's question regarding the question of fact of whether it's nutritionally equivalent, but I think the case law and the remaining cases that we've cited here sets forth that a vegetarian diet is sufficient, is nutritionally equivalent. And as I stated there in the record, all of the meals are required to have the same amount of calories, regardless of what the meal is. And so the court recognized that there's not a right to meat as a religious election, halal meat in this particular case, within a meal. And we believe that there is no such established right.
Question whether that's the issue. What's that Wade case say? That Wade case say? Inmates are entitled, that's Wall versus Wade, I'm talking about 4th Circuit, written by Judge Gregory. Inmates are entitled to religious dietary accommodations, absent a legitimate reason to the contrary. That's 4th Circuit authority.
That's correct, Your Honor. And I don't think plaintiff has presented in the district court has found that he wasn't accommodated. I think Coleman was clearly accommodated based on his religion with the diet that is acceptable under Islamic law, which is what the court is asking. I think in this situation, Mr. Coleman was not getting the type of meal that he wanted, that he felt was acceptable under Islamic law, but he was given this accommodation that he elected. Remember, this is not, they're not forcing him to take a halal meal because he's Muslim. This is an election that Mr. Coleman has made.
Counsel, I just, so I totally understand your argument about sort of the idea that the absence of clearly established law to the effect that if you have a religiously compliant meal that's nutritionally adequate, it would violate the Constitution not to provide a different one that had meat. I understand what you're saying about that. But the rule can't be, right, that if you are entitled to a religiously compliant meal that has, on the package, it says it's the same number of calories, you happen to be allergic to it, but, that's going to have to do. It makes you sick, but that's the one you get. Like, the clearly established right is to a religiously compliant meal that is nutritionally adequate for the person who has to eat it. And so, I mean, I think maybe on the merits in front of a jury, there will be a really interesting question as to whether or not, I don't mean at all to sort of say anything bearing on the merits question of whether this plaintiff will actually be able to prove his side of this factual dispute, that this meal was inadequate and it did cause him these health effects. But I'm just having trouble working through the sort of what appears to me to be a mismatch between the district court's factual findings and then the qualified immunity finding.
I think the court is going a step further by applying the law specifically to Mr. Coleman, where when it's been applied on other bases, it's just been on the sufficiency of the diet itself in comparison to what else was being served. And I think in this particular case, even if Mr. Coleman is provided, he's talking about the nutritional adequacy, even if he's provided the kosher meal that has the meat in it, it's still the same amount of food. It's the same number of calories that he's receiving in the halal meal. So even, if granted the relief as he had requested it, I think he's still receiving the same nutritional value in that case. And it does make me wonder on whether or not he continues to proceed with this case if he's given that meat diet, but he's at least receiving the same amount of calories as he is in the halal diet. So I think the court is taking a step further than where other courts have taken it in saying, applying it to this particular person that has to eat the meal as the court has worded it. No one else has taken it that far at this point that I've found.
Right, but you did not cross appeal that part of the district court's judgment, and you didn't argue any of this in your brief. So I don't know really where that takes us. Can I ask you a question about the equal protection part? So the district court also finds that it's a jury question because a reasonable jury could find not only that there was differential treatment of Muslim and Jewish inmates, but also that the differential treatment was based on intentional discrimination. And that sort of sounds to me like what the district court is finding is that there is a jury question as to whether there was sort of invidious discrimination taking place here, anti-Muslim animus. And if that's right, if we thought that the record created or established a jury question as to whether or not there was anti-Muslim animus going on here, invidious discrimination, can there be qualified immunity for that? I mean, isn't it clearly established you're not allowed to treat Muslims worse than other people?
Well, as the court pointed out earlier, intentional discrimination doesn't necessarily mean worse, right? It doesn't necessarily mean
but I'm saying what if and I am just trying to figure out through my hypothetical question where you are on this. If the record did show, or if the record did give rise to a factual dispute, if a reasonable juror could find that there was anti-Muslim bigotry at work here, would you say that that could be covered by qualified immunity or not?
You'd have to say no, wouldn't you?
I'm sorry?
You'll have to say no to that question. You can't.
That's
make
correct.
Kind of
And I appreciate the second to think about it to make sure. I definitely want to say no, but the answer is no to that. If it's Nefarious is the word I'll use. If it's a question of whether it's nefarious and intentional to the detriment. So if it's purposeful harm, then I believe that plaintiff alleges that in his brief, that you do end up in a situation where we have discrimination, but we'll call it the bad kind of discrimination. My question that I then pose is, why is it that the meal with meat is better than the meal without meat when there are so many vegetarian based, like we're talking about it as if someone receiving a meal with no meat in it is getting something worse than receiving a meal that has meat in it. And so even if we have this,
the judge already ruled, you're asking us questions, but I'll ask you one. The judge ruled that the jury, there was a dispute of fact as to whether there was intentional discrimination, didn't he not?
He did, but
well, and you did not challenge that on appeal. So that
did not.
Settled for purposes of this appeal, that the jury could find that there's a dispute of fact that warrants a jury trial. That's been determined by the judge, but he granted qualified immunity. The
that's
issue
correct. That's correct, Your Honor.
As a legal proposition, the issue I think in the appeal, well, the only thing we have is the qualified immunity award supportable?
And it is, Your Honor, even with that question, even with the court making the findings that they did, when you go through the qualified immunity analysis under Harlow, the court does not find that discernible right, that clearly established right, and the court doesn't find that Jones and Johnson in their position, and remember, it's a reasonable person in their position, would have known their actions violate that clearly established right. And so I think even with the court making the findings that they did, and the court was correct in this, the court can go through and find these issues of disputed fact, but the court is now analyzing qualified immunity because we are seeking civil damages against government officials and nothing else. And the qualified immunity analysis has those two parts.
This is just such an odd case because, right, as I understand it, before the district court, you didn't even argue against this claim of invidious discrimination, sort of anti-Muslim animus. You didn't even argue it on the merits. You were just like, forget the merits. We're just going to come in on qualified immunity. And I do understand that qualified immunity is obviously a sort of, you know, and purposely and appropriately very defendant friendly. So I see why one might do that. But, you know, as I think we all agree, if the district court found a reasonable jury question as to whether there was invidious discrimination here, and you didn't defend against that claim, again, I am concerned that there might be a mismatch between that finding, which is, I guess, sort of law of the case now, and not only did you not appeal it, you didn't even defend against it in the district court, and then a grant of qualified immunity.
Sorry, I'm seeing the red on my time here and it concerns me, but if the court will allow me to go over here to answer that question, we have to remember that qualified immunity in and of itself is procedural in its nature when you think about it. We're talking about the issues on the merits and these violations of law, but the question of qualified immunity is, do we even make it to that point? Do we make it to the point where we are deciding liability, or are the defendants immune? Are the defendants immune from liability, and therefore we don't reach this point on the merits? And so we're talking about this issue as if we can't decide qualified immunity because there are matters on the merits that can be decided, but we have to remember, to get to the merits, we have to overcome qualified immunity first.
Well, right, but to do the qualified immunity analysis, we have to say, are there disputed facts that would allow a reasonable jury to find that something happened here that violated clearly established law? And the district court appears to have held that a reasonable jury could find not just differential treatment, but also invidious discrimination. And if that is true, then I think it is impossible to grant qualified immunity as a matter of law. Because if a jury could come back with a verdict that these people were just like, whatever, we're not interested in accommodating the Muslim, that violates clearly established law. So do you see what I'm saying? Like, I understand that they are analytically distinct, but we do have to figure out whether a reasonable jury could make a factual finding that would then preclude the granting of qualified immunity.
Yes, ma'am. I understand the court's point.
Sorry, I've taken too much of your time.
Do you have anything to say about it? I have a question. You're going to respond to Judge Harris first?
No, that's okay. I'm good.
Let me ask you this, Mr. Kreiner.
Yes, sir.
Are these claims, have you got better argument on some claims than on others, or are the claims a package deal? Do they rise or fall together? And I include in there the state law claims, and I'm going to ask the law student when he gets back up there the same question.
Well, the district court properly applied the state law claims. We don't have any additional.
You say that you've got a better argument.
Oh, I'm talking about the immunity. Yeah, because it all falls on qualified immunity, because remember, qualified immunity is triggered by civil liability, civil damages of government officials. So once you're suing,
so you're saying it's a package. You're saying it's a package deal.
Yes, sir. Yes, sir. Once you're suing for civil damages,
these 5 claims rise or fall together.
Yes, sir.
All right. Thank you very much, Judge Thacker, Judge Harris. Y'all have anything else?
I'm good. I don't have any questions.
Good. Now we got
Thank you.
Thank you very much, sir. And
I appreciate the extra time, and I apologize for dragging on there, Judge Harris. Thank you.
No, that's fine.
Thank you. I appreciate the help.
Being asked questions.
Okay.
But we have a different law student here for the rebuttal. It's Mr. Shriver. Mr. Shriver.
Thank you, Your Honor.
Sir.
Thank you, Your Honor. May it please the court. We agree that the issue here on appeal is qualified immunity, and we agree with some of the conversation so far that nutritionally, there's clearly established law that a nutritionally adequate meal is required, and that is at debate here. We agree with the court's conversation that as long as intentional discrimination is debated, as the district court found, that disqualifies or
yeah, I mean, your co-counsel there said he was going to look, or that he needed to look in the record to answer my question as to whether the officers at the jail at the time knew that anything other than Mr. Coleman saying he wasn't getting enough to eat. Did they know at the time that he was complaining of stomach pains and all of that, or did that come after the fact in this litigation in answers to interrogatories?
It came, we actually found it at the Joint Appendix 252 is the first place.
Right, I found it too. Came after the fact, right?
Well, it came from a visit to the infirmary. It did not come within the litigation. It came during the back and forth with the defendant.
What year?
This was in 2019, Your Honor.
Okay, and the violation, the alleged violation was in what year?
The alleged violation took place over, what was the
wait, 252. Okay, go ahead.
232?
The initial complaint was filed in 2018.
It all took place in 2018. The complaints and the requests and all of that for the compliant meal because he wasn't getting enough to eat were in 2018. So even this visit to the infirmary that you cite to me at JA 252 was in 2019.
Correct, Your Honor.
So what was it that the officers at the jail knew at the time was his issue with the meal he was being served?
So even in Sergeant Jones' deposition, she notes that she was told that he brought to her the complaint that he was not getting sufficient food. That was back in 2017. The place I'm citing to is just the first place it came from a medical source. So this was where it came from an infirmary where he complained of gastrointestinal distress. But early,
right, but he did not complain to Officer Jones or any other officer at the time, at least not in the record, of gastrointestinal distress. That came the following year and also in litigation, correct?
Correct, but to Sergeant Jones, he told her that he was not getting sufficient food and that he needed more food, correct. So she did know that there was a complaint of nutritional adequacy. He did not use the language of gastrointestinal distress at that time, but he did in 2019. Correct.
All he said was he wasn't getting enough to eat, correct?
That's what's in the record, Your Honor, yes.
Okay, thanks.
And so to Judge Harris's question about why we look beyond the nutritional adequacy and the intentional discrimination, where we believe you are right, there's a mismatch between the district court's finding and the grant of qualified immunity, is because we care about all these arguments and we think that Mr. Coleman has arguments that are successful beyond simply mismatches, including the course of choice. And the course of choice is important to us because you actually have established precedent in this court, starting with Jehovah v. Clark, I think 5 years ago, where the court found that being put to a course of choice between one's religious practice and between a government discretionary benefit is itself a substantial burden. And so that's why we believe we have actually multiple avenues by which Mr. Coleman should win this case, multiple avenues by which there are substantial burden, and multiple reasons why qualified immunity does not properly apply here.
Now, which claim is the best claim for you?
Which claim is the best claim for us? Intentional discrimination.
You got a stronger claim, which is the strongest claim for your client?
The intentional discrimination claim is certainly the strongest claim, Your Honor. I think just going back to
equal protection claim.
Yes, Your Honor. I think going back to Judge Harris's question about what we mean by intentional discrimination, in this case, so Crawford L requires specific facts to infer discrimination. And here we have a very specific set of facts. You have a jail that provides meat to Jewish inmates whose religion does not require it, while not providing it to Muslim inmates whose religion does require it. And meanwhile, the Muslim inmates are receiving a meal that's not especially halal, not for Muslim inmates, but it's a common fare diet that's provided to other vegetarian religions such as Buddhists and Sikhs. So you have Jews receiving a meat-based diet that their religion doesn't require, and Muslims receiving a diet that is inferior in their eyes because of the lack of meat in that diet. And I think it's just worth noting.
But these defendants come in at the trial and testify that they didn't know any of this stuff. They didn't know what you're arguing about here now. So they'd beat you before the jury by proving good faith, wouldn't they?
Excuse me, Your Honor.
Good faith to be a defense for them.
Excuse me, Your Honor. I mean, our point here is that, again, he was a Muslim inmate, as I said, who was requesting a meat-based diet, while you have Jewish inmates that were not receiving were receiving a meat-based diet and didn't need it. And so just that differential treatment with no explanation, no penological justification. Again, many of the cases cited by the defense had extensive penological justifications. In one case where a similar concern was raised, the problem was that there was only 4 Jewish inmates and there were hundreds of Muslim inmates, and they could point to financial costs and substantial burdens that would come to the prison. Here, there were no penological concerns. And for those reasons—
Well, there weren't hundreds of Muslim inmates over in Henrico. We're talking about the county jail.
Correct. And Your Honor, I guess—
Henrico County Jail.
Correct,
right?
Your Honor. Correct, Your Honor. I guess I meant only to point to the fact that the differential treatment, the inferior treatment of Muslims went unexplained as opposed to other cases. And for all these reasons, we believe the intentional discrimination claim—
They could explain it before the jury and come clear in the jury verdict. But the question here, all we're going to decide is whether they get a trial or not.
Correct. Correct, Your Honor.
He gets a trial or not.
Correct.
That's right.
And I know I've gone over time here, so I'll just close by saying, and we believe that because this claim and a number of other claims are strong, and that the qualified immunity, for the reasons stated largely by the judges, Your Honors, we believe, we ask that you reverse this grant of summary judgment and find in Mr. Coleman's favor.
We appreciate very much the work of you, Mr. Shriver, and your colleagues there at the University of Virginia, and Mr. Kreiner, we appreciate your work as well. If we were in Richmond, we would, at this point, leave the bench and come down to the well of the court and shake your hands and congratulate you on your performance in this case. But we're not in Richmond, and we can't do that. So we can just thank you and commend you for your efforts. That being said, Madam Clerk, we'll take this case under advisement, and you may call the second case.
second case today, we have case number 20-2348, Lawfer versus Naradia Hotel.
And thank you very much, Madam Clerk. And Mr. Bacon?
Yes, thank you, Your Honor. Good afternoon, and may it please the court. I'll try my best to, with this shifting legal landscape, pack it into the time I have as best as possible. And in that regard, the issue really turns on which Supreme Court precedent applies. Is it Havens Realty, or is it the additional harm requirement imposed by the Spokio Court? I'll start with Spokio. Spokio described two different kinds of statutes. One, to which it applied, is the sort of statute where an injury is created simply by statute and a violation of it is not related to any harm that exists in the real world or even a risk of harm. The example that it gave was an incorrect zip code on a credit report. In that case, the Supreme Court held that what a court must do is look beyond the mere definition of injury in the statute and find something additional before, some sort of additional harm before it can find Article 3 injury. The second sort of statute, which Spokio described, is the sort of statute where there was a real world harm, and when Congress enacted a statute, it made that harm actionable, in which instance the court must look to the terms of the statute for the definition of injury. Courts, that is, that was 2016. That has caused a lot of decisions and a lot of concern in a lot of courts in many areas of the law, including this one. And in June of last year, the court in TransUnion, that's after everybody's briefing in this case, issued a decision clarifying that the additional harm requirement does not apply to discrimination cases. And I'll cite the passage at 141 Supreme Court Reporter 2190, specifically the page break between 2204 and 2205. It states, courts must afford due respect to Congress's decision to impose a statutory prohibition or obligation on a defendant and to grant a plaintiff a cause of action to sue over the defendant's violation of that statutory prohibition or obligation. It cites Spokio. Then it says, in that way, Congress may elevate to the status of legally cognizable injuries, concrete de facto injuries that were previously inadequate at law. And it cites Spokio again. It cites Lujan. And then it also cites Allen versus Wright for the one example it gives, and that is discriminatory treatment. Allen versus Wright, while it's not an ADA case at all, it merely indicates that discrimination it is by itself stigmatic injury and dignitary harm. And the 11th Circuit post-briefing in the Sierra case cited that, it was just before TransUnion, in holding that a disabled person's review of a municipality's website was stigmatic injury and dignitary harm and therefore actionable under Title II. And in the concurring opinion, Judge Newsom had indicated that that was the saving grace that took it out of Spokio. And this, the ADA is exactly the sort of statute, even without TransUnion having clarified that discrimination is the sort of statute, the ADA fits that description. The injuries described by Congress are set forth in its findings of purposes section.
Can we talk about the Fourth Circuit? What does the Griffin case, our case in Griffin, apply here? And if so, how? Or if it's distinguishable, how would you distinguish it?
I'll say the courts which rule against us, I'll cite Griffin for the point that the information must have some relevance to the plaintiff, and for the point that they're, for the notion that they're of no limiting principle if they allow that plaintiff in. But the question then is, first of all, they ignore the Corello court where the Seventh Circuit.
So you think Griffin is against you?
Griffin
Because
is against.
Griffin was a relatively narrow, I mean, it can be viewed as a narrow opinion because there the plaintiff couldn't follow through anyway because he couldn't be a member of the organization he was trying to get information from.
Well, I can advise the court that other courts have looked at Griffin. They ignore the statement in Griffin that it was expressly limited to instances.
Okay, but other courts don't matter really for your case because you're in the Fourth Circuit and Griffin is in the Fourth Circuit, and one of the judges that was on the Griffin panel is now on your panel. So I think your argument about Griffin, if you have one, that it is favorable to you, the Fourth Circuit might be amenable to that, regardless of what other courts say about what we say.
That was going to be my last argument, but yes. So Griffin's no limiting principle and must have some relevance to the plaintiff argument applies only if Havens Realty is overturned or does not apply. If Havens Realty applies, then a person who is deprived of the right to information within the meaning of the statute has suffered injury regardless of having alleged any intent to do anything with that information.
Counsel, I just want to make, so
Judge Harris,
counsel, if that's right, then does that mean Griffin was wrong?
No.
Is that what you're saying? Is it also true that Griffin can only be right if Havens Realty is overruled? How do you reconcile Griffin with Havens Realty?
It's reconciling. It's not whether it was right or wrong, because under Griffin, for example, that plaintiff really did not have standing to sue because he was not deprived of a full and equal enjoyment of the service of that place.
But I thought you would say under Havens Realty, why does that matter? There was a stigmatic injury. I guess for purposes of whether Havens Realty can be distinguished, then I don't see how this case is different from Griffin. But can you explain that to me?
It devolves on whether or not, if one looks at Allen versus Wright and the Sierra case, then it devolves on whether or not that plaintiff is a member of the protected class. The Griffin plaintiff was not a member of the protected class. That defendant owed no obligation, no duty to the Griffin plaintiff. It owed there was no statutory obligation to provide anything to that plaintiff, let alone information. There was no informational right. That plaintiff was not deprived of anything on the basis of his disability because he was not entitled to any enjoyment of the services of that defendant. So never even triggered 121H2. I would disagree with Griffin to the extent that it relied on Spokio, because under the TransUnion case, Spokio does not apply to discrimination. However, Griffin involved, which section of the statute? We don't know. And perhaps it's the auxiliary aids and services section of the statute. It's not, there's no clear statutory regime where, in our case, the regulation, a violation of the regulations, a violation of section 121A2, B2A2, which constitutes discrimination and is therefore, deprivation of full and equal enjoyment of a service and benefit and advantage of a place of accommodation under section 121A.
But when you put it that way, I guess my question is sort of consistent with Griffin. I agree with you, like this regulation is about a right to access these accommodations. And if the plaintiff doesn't want to access the accommodations, I guess I am having trouble under Griffin seeing how there's a sort of a particularized harm there, a harm that wouldn't be shared by anybody else who sort of comes across a non-compliant booking site.
Again,
Could you say, let me give you a hypothetical. What if it was an ADA tester who was not in fact disabled, who comes across the same booking site and sues? Do you think that person would have standing?
No, because he was not deprived of anything on the basis of any disability, which is a requirement of the statute. So no, the answer is no. It has to be deprivation on the basis of disability, and Griffin.
Right, but I thought but I thought you were describing the regulatory regime as being about sort of a right to access these accommodations, and your plaintiff also wasn't denied access to these accommodations because she didn't want access to the accommodations.
If the Department of Justice had wanted to, it had a choice. It could have promulgated the regulation under the clients or customers provision of the ADA, and under, for example, PGA Tour versus Martin, and the Houston versus Merritt case and other cases, then there would have been a nexus requirement that the person at least want to be a client or customer of the defendant. But under Havens Realty, one simply looks at the statutory, and in this case, regulatory scheme under Chevron is to be accorded the controlling weight of law, but apply the definitions of injury created by the statute. Spokio is about whether or not one ignores that and looks past that and has to find additional harm, but TransUnion clarifies that doesn't apply. That does not apply to discrimination. Those are two separate bodies of law, and one does not tread upon the other. I didn't get into the argument where TransUnion also discussed downstream consequences and cites a couple of cases that said, do you apply downstream consequences, or does Havens Realty prevent us from doing that? And they said no, because Havens Realty only applies to discrimination cases, and theirs involve the Fair Debt Collection Practices Act, which are not. So the discrimination case, one looks at the statute and under Havens Realty, and Havens Realty applies and checks off those boxes, doesn't have to allege that they intend to travel to the area. I mean, in this case, this plaintiff actually did go to Colorado, Wisconsin, New York, Maine, Maryland, and back down to Florida, but to put that in as a requirement of allegation, and she did that in July, but to put that into as a requirement of allegations would simply, it would be bad law in our opinion, because.
Counsel, can you do me a favor? Can you explain to me what exactly the alleged regulatory violation is in this case? And I don't want you to I'm not trying to get you into the merits, but I sort of agree with you that what we have to figure out is what kind of an injury is this regulatory regime, statutory and regulatory regime, protecting against? And at least as you argue the case, which is that this is sort of an informational right. There is a freestanding informational right to have this information, whether or not you plan to book a room. Which subsection of the regulations are the hotels violating?
Off the top of it's in my brief, but off the top of my head, it's 36. It's 28 CFR 36.302E. It was promulgated in 2010, and that's the
No, I know it's E, but I guess there's a bunch of, and I'm sorry, I'm not trying to trick you about the regulations. What exactly did these hotels do wrong? Just in common sense English, is there, because the complaint says that they didn't identify or allow for reservations of accessible rooms. And I wasn't clear, is it a failure to identify something about the rooms, or was it a failure to was it not possible to actually reserve the rooms?
I didn't look into the actual specifics of this case, but every single case is virtually the same. Hotels.
They are. The allegation in the complaints is identical, and I don't understand the allegation.
And they have the same violation. In other words, the hotels.
Right, but I don't understand what it is.
They'll have a book now option for, say, for example, a king room, a queen room, double bedroom, river view room, that sort of thing, with a book now option or reserve now button you can click on, and it reserves the room. Yeah. And what it is supposed to do is have an accessible room that you can also click on. So that's the same, and that's reserving a room in the same.
So if I understand that your answer to Judge Harris's question, her question was, what did they do wrong? And I'm hearing you say that what they did wrong on their website was when somebody does a search for a room, they did not offer a handicap accessible room in response to that search. They just
Correct.
offered, okay?
Yeah, and it's two-pronged. And they're also supposed to provide information regarding whether or not the features at the hotel are accessible. And typically what happens is hotels don't, because on the one hand, they didn't want to comply with regulation or something extra to do. And on the other hand, to do so would then reveal the existence of physical violations. They're supposed to identify if they don't have a roll-in shower. They're supposed to identify if the registration counter is not in compliance with the specifications, and so on. Handicap parking spaces and so on. So it's two-pronged. It's providing the option to book and providing the information regarding accessibility. So it's two different. It's really separate into two sorts of obligations.
And would you say your client suffered an Article 3 injury with respect to both of those? Like, how is the failure to have a room available to book an injury for someone who has no interest in booking a room?
Well, through an online reservation service, a hotel advertises nationally and reaches out nationally, transacts businesses nationally to people all over the country in their own houses, on their own computers. And it provided what it provided to non-disabled people, it did not provide to her. And those were services, privileges, and advantages.
But so that's not an informational injury. That's just like there is not a room available for you to book. That's sort of an access injury.
Well, there's the one and the
right. I know. I'm asking you because none of this is in your complaint. I am forced to have this conversation with you at oral argument, so I would appreciate it. It would be vastly more helpful if this was in your complaint. Then I would not have to waste your time here today. And I'm not saying you drafted the complaint, but this is nowhere in the complaint. So I'm hearing this for the first time. Now I am understanding you have two distinct claims. One is there is no accessible room available to book. Got it. The other one is there is missing information about the degree to which I gather the hotel's sort of general facilities are accessible. I'm asking you now just about the first one. The failure of, that's not an informational injury, right? The first one is more, I mean, would you describe that as an informational injury, that there is no room available to book?
That is a good question.
Thank you.
I think that it's to the extent it's information provided electronically to the plaintiff, then yes. And then how, if not, I'm not sure how to categorize it. I mean, if, for example, that would be clearer if that were promulgated under the clients or customers subsection of the same statute, in which case that would be made clear that, or if I suppose that the Department of Justice had issued it added to its regulation that it was for a particular purpose that, well, perhaps, that might be in contradiction. It would have to promulgate it under a separate subsection. There are several other subsections that do have some sort of additional nexus requirement from which additional harm can be imposed. I briefed that ad nauseum in the brief, and I think what's more novel here is the shifting landscape as to the application of Spokio. I think our win or lose this case on whether or not Spokio's additional harm requirement applies, and whether or not Havens Realty does not. And I was really prepared to I argued already why Spokio clearly does not apply to discrimination cases, and Havens Realty does. And I was, to the extent that there are other courts that have ruled against us, they all come up with some conclusion that Havens Realty does not apply. And I was, it's hard to pack that into the time that I have, but I'd like to reserve the time that I've got for my rebuttal argument. But their arguments or their rationale are flawed for various reasons. But once one establishes the two, once the court decides on which applies, Havens Realty or Spokio, then it's the rest of it is simply following the regulation to the statutory framework which establishes discrimination. The question is whether or not the statute can define the injury or whether it cannot.
We've given you some extra time, Mr. Bacon, and you got few minutes left for rebuttal. Let's see what the other side has to say.
May it please the court.
Barrett?
Good afternoon. Stephen J. Parrott on behalf of the appellee.
Parrott.
That's all right. I'll answer anything close to it. It's important that I can convey to the court that in Laufer's brief at page 5, note 2, Laufer limits her appeal to the issue of whether there has to be a physical nexus or intent to return issue. But I have to say that in our brief, we have not so limited our argument. We think that there are some other reasons why the district court was correct in its ruling. We filed a 12B6 motion, and there were some questions about, well, what did you say in the complaint was the violation of the ADA and the regulations, 28 CFR 36302. And part of our problem is that there's an indication that we didn't provide sufficient information. But that
the judge didn't rule on the 12B6 motion.
Well, the judge talked about.
She ruled on the 12B1 motion, isn't that correct?
I'm not sure. I went over that last night and looked at the opinion, and she talks about the district court judge about what has to be alleged in a complaint, and that the plaintiff has the
granted relief under the 12B1, as I understand it, as I read it, and didn't reach the 12B6. Indeed, as I perceive it, if we think she was wrong under 12B1, 12B6 issue be before the court on remand.
Well,
but your brief says she dealt with both of them. Your brief says she dealt with both issues, I think.
Right. Now, if I read it wrong.
I focused on that because I thought your brief was wrong, or I think it's wrong on that point.
Well, I respect that, but respectfully, I thought the court ruled on the motion to dismiss generally. But let's assume, for purposes of this argument, it's 12B1, where in either the complaint or the record before the court, and the record included an October 6, 2020 statement and December 1, 2020 testimony from Ms. Laufer, and really nowhere in there is there any indication as to what was violated under 28 CFR 36302E. And also keep in mind that these were third-party reservation sites. There is an affidavit from an Ashley Cherry from the appellee who said that our websites comply. We put the information on the websites. And in fact, in July, we contacted some third-party sites and asked for a revision. So the question is, first off, what is the violation? And secondly, is it something that is traceable to Noranda Hotels? And we cited to the court some cases that really looked at that issue and what a plaintiff has to prove. The Love versus Marriott case out of the Northern District of California in 2021, Laufer v. Patel, Western District of Texas, 2021, and Laufer v. Arc Hospitality, December 21st, 2021, out of the District of New Jersey. And in those three cases, the court said, hey, wait a minute here, the DOJ guidelines don't spell out what you have to put on the website. And if the third parties don't put on what you ask them to put on, it's not the fault of the hotels. And in our affidavit, which is part of the record, we said, look, we provided this information. There's no requirement under 28 CFR 36302E1 that every single amenity be spelled out. In fact, there's a case I cited to you. The court said it might be okay if you just say it's accessible. And in this case, I don't think that there's any dispute that Laufer didn't check our brand website. She checked third-party websites. On the issue of whether there was a real harm, I don't think there's any question that Havens does not apply and that Spokeo does apply. In Havens, what was outlawed was the statute said you will not make a false or fraudulent statement about properties that are available for rent. And in that case, that's exactly what the defendant in that case did. They made a false statement. But in Spokeo, and in the TransUnion case, I think the general rule has been, and I don't think any circuit or district court rejects this, and that is that regardless of what the statute says, the district court has to make sure that there is a real injury, that it's concrete, and that it relates to the plaintiff, even if the statute itself doesn't, because Article 3 is a constitutional provision and Congress can't bypass it. In this case, while it looks like a discrimination case, it really wasn't, because whatever information was available on these third-party websites that admittedly Noranda Hotel provided information to, the same information was available to disabled people and non-disabled people, and it doesn't become a potential discrimination case unless or until the person going on the site says, hey, I'm going on the site for a reason, and that's to book a room, or I'm planning a trip and I want the information to be able to know whether I can take a trip. I also don't think it's disputed that when you look for standing, you have to look at whether standing exists at the time the complaint is filed. In this case, based on the record going beyond the pleadings, the October 6th statement, December 1st testimony, in both cases, Ms. Laufer said, I have no immediate plans and no serious plans to take a trip outside of up to Baltimore, outside of my home state, until the COVID emergency is over.
Yeah.
In fact, in her testimony,
Counsel,
yeah.
Counsel, can I stop you? Because I don't understand them to be challenging sort of that factual finding. I think we're just here on this question of whether there's, for standing, you have to show the intent to book a room. And on that, I just want to take you back to Havens Realty, because I agree with you that the question here is whether Havens Realty applies, and you say it doesn't because they are the statute. There's sort of a freestanding requirement that you give true information about availability. But here, I mean, there is a regulatory requirement that you give this information about accessibility. And in Havens, I mean, it's pretty clear, right, that as a practical matter, it's not like Congress, this isn't a false statement statute, it's a discrimination statute. Congress wants people to have that information so that they have access to these rental properties. And here, Congress, well, at least the agency wants you to have that information so that people will have access to the rooms. So tell me again why they're distinguishable.
Well, because in Havens, the statute said, as part of our statutory scheme to prevent discrimination, it will be an offense if you give false or fraudulent information about what rental units are available. And so the crime, once that fraudulent statement was issued, or that the offense, civil or criminal, was the giving of the false information.
But how does that distinguish this case where there is at least a regulatory right to have this information? And so the offense would take place when you don't put the information on your website.
But the harm doesn't occur unless you have an interest in actually using the information to book a trip or use it to book a room. The
So you're
harm
saying there's
occurs under
something-
Havens when you give the statement, when you give the false statement.
Is there something you can point to in this statute or the regulatory scheme that lets me know that this, in this case, they only care, the information, there's no freestanding right to information. Congress is not trying to give you a freestanding right to that information. They're only trying to give you a right to that information in connection with the booking of a room. How do I know that from looking at this statutory scheme?
Well, you have to know that from the constitutional requirements under Article 3 that says...
No, I don't, because you're saying that if I look at the statute in Havens, I will see that you are supposed to have that information whether or not you want to rent a room. Fine. And if I look at the regulatory regime here, I will see they are not trying to give you a right to that information, even if you don't want to rent a room. So this really is about the difference, isn't it, in the statutory schemes?
No, and the way I interpret Havens and the 10th Circuit opinion in Lawford v. Looper that discusses Havens is it wasn't simply an informational harm in Havens, it was the giving of a false statement. It was an act, it was a crime or an offense of itself. In this case, certain information must be given to potential people so that they can determine whether there are accessible rooms. But it doesn't become a discrimination unless or until a disabled person wants to try and book an accessible room and finds that they can't find it. And that was the problem. In this case, the discrimination.
Okay, but just that sentence you just said, how do I know that's true? Where do I look in the regulation or the statute to confirm what you just said? That is my question. You read this regulatory scheme so that it is not a freestanding right to information. It is only the absence of information is only cognizable if you plan to use it to book a room. And my question for you is, how do I know that? What am I reading to see that that is true?
You look at the statute. The statute says that you can't treat disabled people different from anyone else. And under the regulations, under section E1 and 2, it says you have to provide this reasonable information. If a person goes on a website and doesn't see the information, there can be no discrimination. There can be no treatment of a disabled person differently than a non-disabled person unless the individual that goes on the website can't find the information and they intended to actually make use of the facilities or book a room.
Yep.
With regard to the, there's also, because injunctive relief is the only relief that can be sought, there has to be an immediate threat that this harm will occur again. And in this case, not only did Ms. Lawford say she never intended to book a room, she's just going on this site to see if it complied with the ADA and regs, but she has affirmatively said she's not going to immediately try to go and book a room or even travel out of state until COVID is over. So at the time this complaint was filed, on its face, there is no indication that there was an immediate or a threat of an immediate harm. In Griffin, the case that everyone was talking about, it says, thus, in order to prevail, Griffin must allege an injury that is concrete, particularized, and immediately threatening. And I think Griffin recognized could not become a member of the credit union and could not utilize the information in any way other than to check.
But didn't Ms. Loeffler indicate that she planned to return to the website again to test their ADA compliance?
She did.
Why isn't that sufficient as a tester?
Well, I mean, in Griffin, Fourth Circuit has said as a tester, that doesn't disqualify you, but as a tester, you have to also show the constitutional requirements for standing, one of which is that you suffered a real harm. So if she went back for no other reason but to see if it complied with the ADA, she's not suffered a harm. If she went back and said, I have plans, definite plans to go visit Baltimore, the Inner Harbor, and book a room in this hotel, that would be a different kettle of fish, but she didn't do that. And in fact, we know from the record, looking beyond her complaint, that from the end of 2019 up to the point of the hearing on December 1st, 2020, she said, I had no plans to leave the state or travel to Baltimore. And so for that reason, I don't think she's alleged or established with her testimony or her sworn statement that she suffered real harm.
I thought she said she was going to travel when the pandemic subsided.
Right. And she looked she went onto the site in July of 2020 and once in August of 2020. And here we are in 2022.
The pandemic's still going.
It's still going on.
Yes.
So can there be an immediate threat of harm?
That's the reason we're in this case remotely.
I'm sorry?
We'd be in Richmond if the pandemic wasn't going on.
Well, that's right. So how did she suffer any sort of personalized injury if her plans had to await something which we don't know when it's going to occur? I mean, when we argued this case, when we were in front of the district,
Pandemic will subside and we can all travel.
yeah. Well,
We were all hoping for that.
yeah, at the time of the hearing,
We're even scheduled to go to Richmond in March and have to plan to do it. But we may not end up being able to do it because of the situation.
well, in December 2020, that's what council indicated that, well, by March, the latest, we're going to travel. I'm sorry?
In this case, she ran that up the flagpole in this case that I'm going to do something after this pandemic's over with.
Well, that's right. And for that reason, under the constitutional requirements of a real threat of an imminent harm, she cannot and could not meet her burden. She didn't plead it. And to the extent we're looking at the factual challenge only, she didn't offer any proof to prove, one, that when she went on the site for the first time, she intended to book a room, and two, that in the near future, she was going to go back on for the same purpose. Now, and I also want to point out, with the time I have left, there's reference in Lawfer's brief to a minority opinion that the courts have said, well, it's a minority opinion that you have to show an intent to utilize the services or book a room. And I don't know how you define minority opinion, but I looked, in the 4th, 5th, and 10th circuits, in my view, have come out and said, you have to show an intention to book a room or to utilize the services of the defendant. And then in terms of district courts in the 1st, 2nd, 3rd, 6th, 9th, 11th, and DC circuit have taken that same position. The 11th Circuit Court of Appeals.
You say the 4th has?
Well, in Griffin,
You're claiming Griffin controls here.
Well, I do, and I think the district court felt the same way.
It's already got us counted in.
Well, I got you counted in the closed-end credit union case. I'm hoping it'll be the same in this case.
But you just said that you could have mailed it in. It just said, well, Griffin takes care of this. We don't even have an alternate, couldn't you?
Well, I think the only thing that distinguishes.
If we agree with you on Griffin, or say it's distinguishable, you can't count us.
All right.
I was on Griffin. I filed a concurrence. Matter of fact.
Well, and to me, the way I read Griffin is that in that case, he could not utilize the services.
I thought it was a very limited ruling on myself.
Well, it was, and I think the court was very careful not to go beyond the issue presented. But I think part of the issue was whether the individual could show a real injury that was concrete and particularized. So I see my time's up, and I'm happy to respond to any questions.
Judge Thacker, Judge Harris, y'all got any further inquiries?
I do not.
Nope, thank you.
Mr. Perrott, we appreciate your argument. And Mr. Bacon, you deserve the short rebuttal.
Thank you. A lot of issues raised, but Havens Realty. Havens Realty was I think it was 1986 case, different statute. different type of discrimination. There's racial discrimination under housing. Fair House, the court, there were multiple plaintiffs. One of them was a plaintiff.
Counsel, just because you have so little time, I did want to ask you a question about Havens, and it's the same sort of question I was asking your colleague. So the court in Havens reads that statute as providing sort of a freestanding, independent right to truthful information, whatever you're going to do with it. And so my question is, I think under Havens, I have to look at this statute and I guess the regulatory regime, and we're all assuming here that that the same rules would apply to these regulations as would apply to a congressional statute, and figure out whether they also provide this kind of freestanding informational right. You are entitled to this information even if you don't plan to use it. And so my question is, when I look at these regulations, they do seem to at least contemplate that the person will use it, will be using the information to book a room. In that, I really struggle with E1-2. You have to describe the accessible features in the hotel in sufficient detail to permit an individual with disability to figure out, to assess whether the hotel is going to meet his or her accessibility needs, which is sort of the language you would use, I think, if what you have in mind is people who want to stay in this hotel need this information.
A couple things on that point. First of all, it never said that such was a requirement. That, in other words, that they had to intend to book with the hotel, or that they.
Right, no, I'm sorry. I know it doesn't. I just read you the relevant language. Yeah.
Yes.
I know what it says. I just read it to you.
And what it could have done, as I said, was the best place, if it wanted to impose that obligation, would have been to promulgate it under there's a clients or customers subsection of 121822, which requires that the plaintiff be a client or customer of the place of public accommodation in order to have any rights under that subsection. And so therefore, that, the fact that that requirement exists there and not under the subsections which govern here, under the rules announced by the Supreme Court in cases we cite in our brief, as well as Houston versus Merritt and whatnot, then what counts is that you have restrictive language in one subsection, but not in the one that applies. And that goes back to whether the court even honors that, and really brings it back to, does Spokio trump that requirement or does it not? And Havens Realty, while one talks about racial discrimination and intentional misrepresentations, Havens Realty is about applying the literal terms of the statute. It was a different statute. The ADA was promulgated afterward, and it used the same operative language. And the 10th Circuit, even though it just came out with a Looper opinion, which eviscerates its prior opinions, the 10th Circuit in Tandy and the 11th Circuit in Houston versus Merritt, that's a case I argued, used the rules of statutory construction and said that, well, you apply that principle to the ADA, even if we're not talking about information in the ADA, because those were physical barrier cases. Houston versus Merritt was about, absence of grab bars and handicap parking spaces, not about the right to information. But that still extrapolated over, and those two courts, based on the application of Havens Realty, held that testers have standing. And you read the literal terms of the statute. That was then followed by the 9th and followed by 3 other circuits for a total of 6. And that would include this court's decision in Aberdeen, which doesn't say a whole lot, but follows Houston versus Merritt. I think I've exhausted what I have.
Bacon, I believe you've used your rebuttal time, I believe. We really appreciate it. The work that both of you have placed into this case, and we appreciate your arguments. We're sorry we're not in Richmond, where we would leave the bench and congratulate you at the council tables on the arguments that you presented. But maybe next time. With that, we'll take your appeal under advisement, and Madam Clerk, can we take a 5-minute recess
Yes, sir.
before the third case?
Honorable Court will take a brief recess.
We stay on the line. Yes, step right up. That's that tax case.
Court of Appeals for the Fourth Circuit. Our third case is case 21-1411, Guardian Chapter SP versus Rothschild.
And for the appellant in the third case, Mr. Aby, is that the correct pronunciation?
That's correct, Your Honor.
Good to have you with us, sir. You may proceed.
Thank you, Judge. May it please the court, Matt Aby of Nelson Mullins here for Appellant Guardian Tax. Your Honors, before 1966, a senior lien holder could extinguish a G2 of the South Carolina tax sale process. And second, when is the IRS entitled to that notice? Here, Guardian provided the IRS with a summons in a quiet under 7425A. The IRS is subject to being divested upon the entry of a judgment in that quiet tax title proceeding. The IRS disagrees, though, and says that it should have.
Counsel, sorry, I don't want to cut you off at the beginning, but the argument that this is a judicial sale case under subsection A, that was not presented to the district court, right? So why should we reach it here?
Yes, Your Honor, we believe that it was encompassed in the theory that was presented to the district court. There are several parts of in the appendix that I could point you to.
No, that's okay.
Yes, Your Honor.
That's okay. I mean, it was, I followed this, I followed your argument in your briefs, and I understand that you sort of got to the same place with some of the arguments you were making in your brief, but to say, I mean, it seems 100% clear that this was argued our normal practice here and go ahead and address these arguments.
There is, Judge. So under Nelson, the Supreme Court's opinion in Nelson, we don't have to put a particular incantation, a particular set of words in order for the issue to be read. But they are arguments that are just fleshed out from the arguments that were presented to the district court. But under the under this court's precedent in Arrakis in 2020, the court can consider it, and that's especially true when it's a legal argument. All the parties agree that there are no factual issues here, that these are purely legal issues, and the court can consider it.
Well, I've always understood it to be, Mr. Ady. The principle is you need to give the district court a fair shot at the question. You need to bring the case, the issue before the district court, give the district court a chance to rule. Otherwise, you come to the Court of Appeals and you're ambushing the district court. Well, that's the point. We're a court, we're supposed to be a court of review, not first view. We've said many, many times.
Yes, Your Honor, and I generally do agree with that. The court, though, has wider latitude when we're talking about a legal issue to address that on appeal, even though the particular issue wasn't addressed at any length to the district court below. But I will say that the theory was very clearly presented to the district court. And looking at appendix page 34, which is the district court's order, the district court says, quote, plaintiff next argues that the proper remedy is to give the IRS 120 days to redeem the property rather than permitting the federal liens to remain on the property. That is the crux of our argument here.
No, it's not the crux of your argument. We don't have to get bogged down in this. I totally appreciate that remedy question is preserved in the district court. It's just that it was preserved under subsection B. If there's been a violation of subsection B, what's the remedy? But I absolutely agree that this remedy question was in front of the district court.
Well, Judge, let me address that remedy question. So the second issue that in my introduction I mentioned was when is the IRS entitled to that notice? And the IRS states that they should have received a certified mail notice earlier in the process. And the IRS mistakenly applies 7425B, but they also misinterpret their own definition of the date of the sale. The IRS wasn't entitled to certified mail notice because at the time that a certified notice could have gone out, the IRS was not at risk of having its lien divested. That couldn't happen until the judgment is issued in the quiet tax title proceedings. So therefore, the date of the sale, regardless of whether the court applies 7425A or B, the date of the sale is the date that the judgment is entered in the quiet tax title proceedings. Here, the IRS has received notice. They are fully aware that Guardian is attempting to divest it of its lien because under South Carolina law, the date when that would occur as a junior lien would be the date that a quiet tax title judgment is entered. So,
Counsel, I know this is like a really technical area and common sense does not always prevail. So I do fully understand that. But it's weird, right, to say that a sale of property takes place after it's been sold at auction and after title actually has literally passed to a third party. You're saying the sale of that property took place at some point after that? That is unusual, right?
I agree. It is unusual, but that was how this term of art is defined both by the IRS and by Congress when it was attempting to put this federal scheme across all 50 states. And the IRS, when we're looking at their Treasury regulation, and I'm talking 301.7425-2, the IRS attempts to define date of the sale, and it gives you three different options as to what the date of the sale is. And the key point here is looking at divestment of junior liens on the property, and it's resulting directly from the public sale. Here in South Carolina, there is no divesting of junior liens at the auction. There's no divesting of junior liens at the time that the tax deed is issued. Junior liens can only be divested under this statutory quiet tax title proceeding, which is very specific to South Carolina, and it's distinct from your traditional common law quiet title action. So under the IRS's definition of date of the sale, we look to B3, which is the date on which the IRS could be divested, or junior lien holders could be divested of their interest in the property. Now, the IRS also gives some examples in that regulation, examples 5 and 6. And when we're looking at that, we're looking at when the junior liens are divested. And in fact, in example 6, the IRS says that the date of the sale is, quote, the date on which the holder of the tax certificate obtains absolute title. When you're looking at the quiet tax title action in South Carolina, Guardian cannot get absolute title until a judgment is entered in the quiet tax title proceedings. So yes, while I agree with you that common sense would say that the sale, a non-judicial sale or judicial sale, is the date when the public auction takes place, because that's what we would think of traditionally as a sale, the term of art says that the date of the sale can be a later point. And here that is when Guardian would obtain absolute title, so the date when the judgment would be entered. So because then there's no, because then the date of the sale is the date of the judgment, the IRS would get 120 days from that date in order to redeem. And so the IRS gets exactly what the 1966 Federal Tax Lien Act anticipated, which is notice and an opportunity to evaluate its position, look at the value of the property, look at the value of the liens, the amount that it would have to pay, and determine whether or not there's enough equity in the property that it would like to redeem and move forward with that redemption. They've got breathing room to do that, 120 days from the date that the judgment is entered. So therefore, Your Honors, regardless of whether we apply subsection A or subsection B of 7425, the date of the sale has not occurred yet.
Oh, I'm sorry, there has been, the date of the sale has not, it didn't occur at the quiet title action?
No, it's not the filing of the quiet title action. It is the date that the judgment is entered in the quiet title action. Because under South Carolina law, that's the date in which junior lien holders can be divested. Okay. That's when the court can order that junior lien holders are barred from their claims. So, Your Honors, when we're looking at that date under South Carolina law, we look then at the quiet tax title proceedings, and the statute says that the proceedings are supposed to be liberally construed to afford a complete remedy to a party like Guardian. And when we liberally construe that, of course, within the constraints of Section 7425, we see that the date of the sale has not yet occurred. The IRS now has already received notice. And so effectively, the purpose of the 1966 Federal Tax Lien Act is satisfied here. I'd like to move next, Your Honors, if I may, to the equitable subrogation argument. This equitable subrogation argument was raised below, and it was not resolved by the district court, of course. We believe that that was error because when we look at the Dietrich case from the Fifth Circuit, the court there said that you must consider the state law of equitable subrogation when you're looking at an issue like this. And the district court below did not entertain this, did not make a ruling on it, even though that we made it very clear that the IRS would have been jumping in priority and would have received a windfall if the court allowed the property or the IRS lien to remain on the property. So here, under that Dietrich case, as well as the other cases that we cite, because Guardian had no knowledge of the IRS liens, because it effectively paid off two senior liens, senior to the IRS, we get to stand in the shoes of both the county who held the tax lien as well as the bank who held the mortgage on the property. And so we would ask then that the court reverse and rule here that Guardian is equitably subrogated to those interests. Your Honors, if there are no further questions, I would just ask that the court here reverse and then remand so the district court can enter a judgment giving the IRS 120 days to redeem the property or be divested of its lien. And your Honors, I'm happy to answer any other questions the court may have or reserve the remainder for rebuttal.
Yes, Ms. Avetta?
Thank you, Your Honors. May it please the court. Julia Avetta for the United States.
Good to
The
have you
Internal
back.
Revenue
Sure.
Code, thank you, Your Honor. The Internal Revenue Code sets forth clear rules to discharge a federal tax lien through a non-judicial sale of property, which is what the Charleston County tax sale was. Those rules were not followed here, and for that reason, the federal tax liens on the property were not discharged. There's no dispute that federal tax liens against Ralph and Virginia Day attached to the property at Ocean Boulevard. There is no dispute that notices of these federal tax liens were filed more than 30 days prior to the sale of the Ocean Boulevard property as required by Section 7425B1 of the code. And there's no dispute that Charleston County did not provide proper written notice of the sale to the government as required by Code Section 7425C1, subsection 3A1 of the Treasury Regulation 301.7425, and the IRS Publications Directing Service. The county did not follow these procedures, and that's not in dispute. The county conducted the sale in accordance with South Carolina law. Guardian concedes at their page 19 of their brief that South Carolina law does not require notice to junior lien holders other than mortgagees. But South Carolina law does not operate to discharge a federal tax lien. Federal law does. So because the Internal Revenue Code statutory conditions were not met, here, the district court correctly held that the Charleston County tax sale did not discharge the federal tax liens from the Ocean Boulevard property. Those liens stayed on the property. Guardian took title to the property subject to those liens. And that was the conclusion of the sale. At that point, Guardian held presumptive good legal title under South Carolina law.
Counsel, sorry, I just want to make sure, Counsel, I just want to clarify, what is it that you think was the date of the sale for purposes of this notice requirement?
The date of the sale was October 31st, 2016. That was the auction date. And a year later, the conveyance ripened into a deed, which was recorded, but the presumptive title was conveyed as of the date of the auction.
The auction itself. And what do you, sorry, you're probably about to answer my question. Go ahead.
Well, I hope so, Your Honor. That language, that when you determine when that date of sale is, how you pinpoint that, comes from the hanging paragraph at the end of subsection A in Treasury Regulation 301.7425-2. And that defines a non-judicial sale as the act that divests the taxpayer's interest in property by operation of law, by public or private sale, this was a public sale, or by certain other conditions not applicable here. So the moment you're looking for to determine when the sale occurred is not when title is cleared of junior liens. It is the moment when the taxpayer's interest in the property is divested. And that happens here when Guardian buys the property. And Guardian accedes to the rights of the taxpayer in the property. And that's what the tax deed says. And it says it at page 65 of the appendix. It's clear that they're taking title. And as Judge Harris has observed, that's traditionally when you understand a sale to take place. Now, the availability of subsequent judicial proceedings unrelated to that sale, which are permissive, which the purchaser need not even pursue, does not change the nature of that sale as a completed transaction as of the date of sale. And here, we know that the county tax sale concludes with a deed that conveys title to the purchaser after the period of redemption runs, and that title is presumptive good title under South Carolina law. There is no judicial action necessary for the taxpayer's interest to be extinguished and the title to vest in the purchaser. The purchaser has the choice, has the option under South Carolina law to bring a quiet title suit if junior liens remain on the property. But that is permissive. That is not mandatory. It's not part of the tax sale. It's not even particular to tax sales. The governing provisions of the South Carolina Code make clear that a quiet tax title suit is conducted just the same as any other quiet title suit. And it's not a part of the sale that's already completed. Subsequent proceedings don't change that the transfer of title, and not before, is when Guardian will step into the shoes of the taxpayer and even obtain standing to bring a quiet title suit. By that time the suit is filed, the tax sale, the non-judicial county tax sale, is complete. Turning next to Guardian's contention that they are entitled to equitable subrogation, we suggest that this argument was not adequately briefed before the district court, but we note that this court can affirm for any basis in the record, and we submit that the record demonstrates that Guardian does not meet the requirements for what at the bottom here is an equitable remedy. The Internal Revenue Code, Section 6323I, only allows subrogation to the extent provided by local law, and South Carolina law of subrogation requires 5 distinct factors to be met. The first of those factors is that the party has paid the debt. Here, Guardian only paid the debt of the owed to the county, the ad valorem tax liens. Some of the purchase price went to costs of sale and other incidents, but the surplus of the sale price after the county's claims were satisfied was paid to the bank, and the bank's mortgage was extinguished. Guardian has paid nothing on behalf of the bank. The second condition is that the party seeking subrogation is not a volunteer, but had a direct interest in the discharge of the debtor lien, and this is where Guardian's doomed. Because before they bid on the Ocean Avenue property, Guardian had no interest in the property, and they shared no obligation with anyone who did. South Carolina law further requires that a party seeking subrogation be secondarily liable for the debt, but Guardian was a stranger to the taxpayers here. They were under no obligation to satisfy their debts as well. And finally, the fourth factor is that the party seeking subrogation did not have actual notice. But here, it's undisputed on the record that Guardian didn't bother to do a title search. Equity will not reward a lack of diligence by granting a factor in favor of lack of notice when they decline to do any due diligence. And finally, the fifth factor is that—
Ms. Avetta, was there any explanation, or is there any in the record, on why they didn't do a title search?
The district court did not. The district court noted that the cost for them to do so would be de minimis, but other than that remark, I am not aware in the record of an explanation for why a title search was not procured. We know they did procure one eventually after they made the purchase.
But the district court said it would have cost $400 or $500. Is that what it was?
A few $100s. It's certainly a minimal amount of the 7 figures that they invested in the property.
But it was never no explanation tendered as to why the title search was not made.
No, Your Honor.
Thank you.
The fifth and final factor to obtain subrogation in South Carolina is that no injustice be done to the other parties secured in the property. And that's not the case here, because since the non-judicial sale was completed, and the federal tax liens were not extinguished, the federal tax liens are now in first position on the property. In fact, there is a lien enforcement proceeding that has been commenced in the district court in South Carolina. That is case number 213998. And the addition of subrogation into this mix would demote the priority of the United States tax lien and would also impermissibly grant to a private purchaser the rights of a state sovereign creditor. And the equitable remedies do not extend that far. They certainly do not displace the complex yet clear federal governing regime for federal tax liens, which preserves those liens on property where proper written notice is not provided to the United States. Because that happened here, the liens remained on the property. Guardian has shown no error in the decision at the district court, and this court should affirm. We are happy to take any other questions.
Judge Thacker, Judge Harris?
I don't have any questions.
I don't either.
Thank you very much.
Thank you.
Mr. Abey?
Yes, Your Honor. If I may go back to the date of the sale and why the IRS is incorrect in the way that they interpret the date of sale. My colleague just said that you should look at the hanging paragraph in 301.7425-2 to determine what...
Did the district judge find the date of the sale?
The district court judge did not. But that was presented to the district court as far as our argument goes, when we argued that the IRS should receive 120 days from the date of the judgment to determine whether or not it should redeem. And so, Your Honor,
go ahead.
If I may point you at this, so this hanging paragraph here that the IRS points to, that is trying to determine the distinction between judicial and non-judicial sale. That hanging paragraph actually doesn't define the date of the sale. The date of the sale is defined in paragraph B, which is titled date of sale. And it gives you three different options. In the first option, it talks about when there's a divestment of junior liens resulting directly from the public sale, then the date of the sale is the date of the auction. Here in South Carolina, the public auction does not directly result in the divestment of junior liens on the property. Junior liens cannot be divested until a quiet tax title judgment is entered. So therefore, this first subsection can't apply. On subsection 2 can't apply because that talks about divestment of junior liens resulting directly from a private sale. There's no private sale here in South Carolina. It's a public auction, so subsection 2 doesn't apply. So then you come to subsection 3, and that says in the case of divestment of junior liens on property not resulting directly from a public or private sale, the date of sale is deemed to be, quote, the date on which junior liens on the property are divested under local law. So what the IRS is doing is they are conflating what type of sale this is, whether judicial or non-judicial, and the analysis under this subsection B for date of the sale. Because there's no divestment of junior liens in South Carolina until a judgment is entered, the date of the sale is the date on which the quiet title judgment is entered. And that's exactly what example 6 of this same regulation says. It says, for the purposes of computing a period of time determined with reference to the date of the sale, is the date on which the holder of the tax certificate obtains absolute title. And that date is the date when a court would enter judgment in the quiet tax title action. So the date of the sale here has not yet occurred, and we would ask that the court reverse the judgment so that the district court can enter judgment saying that the IRS has 120 days to redeem or be divested because they've received notice of this sale at this time. Your Honor, I would like to next talk about the title search, and I would point the court to 438 through 440 of the appendix. And that's where Guardian explains the reason that it can't do a title search in every single case. In part, it would be cost prohibitive to do title searches. But more importantly, the title search wouldn't really matter before the auction. And this is because the date at which the IRS would be subject to being divested would be later on in the process. It would be after the quiet title action had been filed, the IRS had been served, and the court issues a judgment. So whether or not there's an IRS lien on the property is immaterial at the time that there's a bidding on the property. And that's whether or not you apply subsection A or subsection B. It's later in time when the divestment of the junior liens would occur. So the fact that the IRS liens on the property doesn't matter at the time that the auction occurs. Your Honors, this all goes back to the whole purpose of the 1966 Federal Tax Lien Act. And we've cited several different cases, but the Myers case, which is cited by the IRS in its brief, goes through a lot of the reasons for Section 7425 and explains that the history and purpose was to make sure that after the Supreme Court's opinion in 1960 in Brosnan, that the IRS received notice before its junior lien could be extinguished. Here, that purpose has been effectuated because the IRS has received notice of this sale and has the opportunity to redeem. We'd ask that the court reverse so that the district court can enter judgment, giving the IRS 120 days to redeem or be divested of its interest.
Thank you, Mr. Avey. We appreciate the arguments of counsel, and we sincerely wish we could visit you in person and well of the court and congratulate you on your performance of oral argument. We can't do that, but we will next time you're here. Madam Clerk, we'll take this case under advisement, and you may call our last case. Thank you, Madam Clerk. And the appellant is the Attorney General, Mr. Wilson. Mr. Mills, you represent the appellant, as I understand.
Yes, Your Honor.
Good to have you with us, and look forward to your argument.
Thank you, Your Honor. May it please the court. South Carolina's Act advances its important interests from the outset of pregnancy in protecting unborn life and maternal health. Under the Act, the abortionist must give the mother the opportunity to view an ultrasound, hear her unborn child's heartbeat, and receive information about her child's development. If the abortionist doesn't do those things, the mother under the Act can sue him for at least $10,000. The abortion centers here are trying to take away that right from the very women they purport to represent. They don't assert their own rights, and they don't directly challenge these provisions or most others, yet the district court enjoined them all. Though the underlying policy questions are controversial, the three legal issues presented here are straightforward under established rules of federal litigation. The parties who brought this case do not have third-party standing or a cause of action under Section 1983. They have a unique...
Counsel, sorry, can I just ask you a question about the issues that are before us? Are you challenging on appeal the district court's holding on likelihood of success that the fetal heartbeat ban is unconstitutional?
We continue to challenge that. That's the single challenge provision, Your Honor. We continue to challenge that below. That's not an issue on this appeal, so you may assume for purposes of our severability argument here that the district court's holding on that issue was fine.
So for our purposes, you're conceding the heartbeat ban is unconstitutional?
No, Your Honor, we're not conceding that. We are conceding for purposes of the severability. You may assume that that provision won't go into effect, but we obviously disagree with the district court's finding, even as to the single challenge provision.
But you're not challenging that ruling.
That is not an issue before this court.
That ruling stands for purposes of our appeal.
That's right, Your Honor.
Okay.
All right, it stands. Not assuming that it stands.
That's right. We've not challenged it on this appeal.
Not challenged.
So you do not challenge that you are not likely to succeed on the merits, correct?
That's not correct, Your Honor. We do not challenge that we are. only as to subsection 680A, which is the only provision that the plaintiffs here allege violates anyone's constitutional rights, of course, not their own, someone else's. So going back to what I was saying, they don't have third-party standing because they have a unique conflict of interest in trying to deprive the women they supposedly represent of statutory rights against them. And dozens of precedents say that Section 1983 claims are limited
Well,
to
what's the conflict?
I think it's that if an abortionist doesn't follow the act, the mother can sue him for $10,000. And here, the abortion centers are trying to take away that right of the mother, of the very person they purport to represent. There is no case that sanctions third-party standing in the face of this sort of conflict of interest. Indeed, if a conflict of interest means anything for third-party standing, this has to be one. It must be the case that a third party cannot come into court and say, first party, you won't be able to sue me anymore, but I'm asserting your rights. So,
okay, go ahead.
Even if the plaintiffs here had standing in a cause of action, they would have no plausible argument to extend any preliminary injunction beyond the single challenge provision. The act is.
Well, let's go back to standing then. So what precedent do you have that Planned Parenthood does not have third-party standing?
I would say the case we cited in our blue brief on page 23, the case we cited in our gray brief on page 5.
Why don't you just say the name of the case? Do you have one?
Well, yes, Your Honor, there are a bunch of them. One of them would be this court's decision in Stanley versus Darlington County School District, 84 F 3rd 707.
How about a Supreme Court case? Do you have a United States Supreme Court case that says that clinics do not have third-party standing in these cases?
Well, Your Honor, the question isn't about abortion clinics generally. This question has never been before the Supreme Court. A clinic has never been before the Supreme Court.
My question was about abortion clinics generally then. Do you have any U.S. Supreme Court cases that say that clinics that provide abortions or doctors that provide abortions do not have third-party standing on behalf of their patients?
If they are trying to deprive their patients of rights, then Elk Grove says that they don't have third-party standing, because Elk Grove says that even a potential conflict of interest prohibits third-party standing. If that's true, then here, where you have an actual inescapable conflict of interest, if we win, the women we purport to represent can no longer get $10,000 from us. That must be a conflict of interest sufficient to destroy third-party standing. If in Elk Grove, even a potential conflict of interest between a father and his son was sufficient to eliminate the possibility of third-party standing.
And what was the conflict of interest in Elk Grove?
It was about the Pledge of Allegiance and whether the father's interests were actually the same as the child's in avoiding
him. Well, that's far different than a healthcare provider and patient. But I guess you premised your answer to me on if we're talking about this conflict of interest. Okay, what if we do not agree with you that there's this conflict of interest? Is there any Supreme Court precedent that healthcare providers that provide abortions do not have third-party standing on behalf of their patients?
Putting aside all the conflict of interest, of which we believe there are several, the $10,000 being the most obvious,
right?
Then even under the long settled test for third-party standing, they have to allege at least a close relationship and a hindrance.
I asked you for a case.
Sure, Kowalski. The Kowalski case says that parties have to allege, third parties have to allege a close relationship with the third party, with the first party, and a hindrance to that party in bringing suit. They've never attempted to do that here. So
and
the fact that
it involves healthcare providers that provide abortions?
No, Your Honor.
Well, my question was, do you have any United States Supreme Court authority that says that healthcare providers that provide abortions do not have third-party standing on behalf of their patients?
No, Your Honor, because in other cases that
Okay,
have
then now
involved
you can go on.
Thank you, Your
There
Honor.
is no precedent. See? Go ahead.
Well,
I'll try not to interrupt you the next time if you just answer me.
Your Honor, with all due respect, what there is not precedent for is a first party being deprived of their statutory rights against the third party in the exact same suit. There is no precedent for that sort of conflict of interest to exist and for third party standing to be found. In other cases, I agree with Your Honor, abortion providers have been able to show that there's a close relationship and that there's a hindrance and that there's no conflict of interest. But here, the abortion providers haven't even attempted to show those things. They've refused to discuss them at all. They haven't alleged the predicates. And as this court said in Freilich, which Judge King joined, a failure to allege or prove even one of those requirements is fatal to any claim of third-party standing. So whatever happened in the Supreme Court's other abortion cases, where the facts were different and the allegations were different, and most importantly, the law was different, those are different from this case. No court has found third-party standing when confronted with a conflict like that exists in this case. Again, I would point this court back to its decision in Stanley, 84 F. 3rd 707. There, a school district sought to file a claim against the state for contribution on behalf of a class that included the same victims that had sued the school district. This court said that such a conflict is disqualifying because the school district would have been required to promote the very claim it was resisting. The same is true here. The abortion centers are pressing a claim that an injured woman would be resisting. So they don't have third-party standing. They also don't have a cause of action under Section 1983 because claims under that provision are limited to the party personally deprived of constitutional rights. They are not that party. Courts universally hold.
You're pursuing 3 issues on appeal, is that right?
That's correct, Your Honor.
But that doesn't include the merits.
It includes the merits of the vast majority of
the and all the only issue we have to decide is whether to sustain the injunction, which
That's
we
correct.
review for abuse of discretion.
Your Honor,
an injunction for abuse of discretion. Is that correct?
that is correct as to balancing of the factors, but that is not correct as to legal issues. This court reviews legal issues as the likelihood of success.
We review the award of an injunction for abuse of discretion. If you could convince us that there was an error of law made somewhere that implicated the thing adversely, then an error of law could constitute an abuse of discretion. But the review is for discretion. That is, as to Judge Lewis, did she abuse her discretion in entering this injunction? And that's what you're trying to convince us. But you raised 3 asserted legal errors, but don't challenge the constitutionality of the statute.
Not quite, Your Honor.
The merits. You leave that unchallenged.
No, Your Honor, we do not believe they're likely to succeed on the merits because they do not have third-party standing. We do not believe they're likely to succeed on the merits because they cannot state a claim. And we do not believe they're likely to succeed on the merits because they do not challenge the vast majority of the act and have no plausible argument to extend the preliminary injunction to the unchallenged provisions. So I've addressed third-party standing. As to the Section 1983 argument, all precedents, dozens of on-point precedents hold that those claims are limited to a party who alleges a personal deprivation of constitutional rights. Just recently, the Second Circuit in Connecticut citizens.
Can I ask you a question about this? I know you have some cases from other contexts, and tell me if I'm misunderstanding something, but all the cases finding that abortion providers do have third-party standing to assert the rights of women whose rights are being indirectly infringed, those are all Section 1983 cases. They are all effectively holding that the doctors have third-party standing to assert these claims under Section 1983, right?
Yes, Your Honor.
I'm anticipating your response will be nobody thought to make this argument in those cases. But nevertheless, we would be undoing 50 years of settled practice in a context in which you didn't raise this argument before the district court, and the district court did not analyze it or discuss it in the order under review. And that just seems like a mighty big step to even consider taking in this procedural posture.
Thank you, Your Honor. A couple points. So first, there are dozens, again, if not hundreds of on-point cases that directly apply here. I agree that in several federal court cases involving abortion providers, this issue wasn't raised. But an issue that's not raised or discussed is simply not a precedent.
Why was it not raised in this case before this judge?
Well, it was raised below. It was primarily argued on the motion to dismiss, where the district court said—
I'm sorry, you're not arguing that it was raised in the preliminary injunction proceedings, correct? You did not argue this in the preliminary injunction proceedings.
Your Honor, we addressed third-party standing generally. According to the district court, it decided—
Well, can you just answer my question? Did you raise this argument? Apart from third-party standing, even if there's third-party standing, you lack a cause of action under 1983. Was that argument raised before the district court?
It was not raised.
During the preliminary injunction proceedings?
It was not raised, but it was passed on, according to the district court. And where an issue is passed on, this court may consider it.
I read the district court very differently than you do. I think it would have been the world's, let's just say, a large coincidence for the district court to have reached out to address an argument that was not before it, that is, let's just say, novel in light of several decades of case law. I understand the district court in her later order to be saying, look, I already determined that providers have third-party standing, the issue that was raised in the preliminary injunction proceeding under Section 1983, and the district court appears to believe, as do all the courts to address this, that that is enough to resolve, in addition, any separate sort of statutory standing cause of action question, because all of these cases hold that when providers have third-party standing, what they have third-party standing under is Section 1983. So I do not understand the district court to have been saying, I read your minds during the preliminary injunction proceeding. I intuited somehow that you meant to break what has always presented as one claim into two claims, and I separately addressed the unstated second claim.
Well, Your Honor, we just take the district court at its word, and it separately, in the motion to dismiss order, addressed third-party standing from Section 1983. And at Joint Appendix 197, it said it previously concluded that plaintiffs are able, quote, under Section 1983 to assert a claim on behalf of their plaintiffs. Then it applied law of the case. And then the abortion centers, trying to get quick summary judgment, said, quote, the district court's legal analysis in the preliminary injunction order forecloses defendants' legal arguments as to third-party standing, severability, and plaintiff's ability to state a claim. That's docket 105, page 3. So they're trying to have it both ways. They're telling the district court that no, Section 1983 is law of the case. You've already decided this. You don't need to consider it anymore, while telling this court, oh, no, the district court hasn't decided it yet, so you can't decide it. Finally, Your Honor, on that issue, I'd say even if it wasn't pressed or passed on below, and the district court said it passed on it below, it's a pure legal question. There's no factual development necessary. It was fully briefed here and there, and the alternative would be to go back down, move to the dissolve the injunction, and then come right back before this court. And then I would simply go back to the severability point, which is that even assuming that the single challenge provision is enjoined, any preliminary injunction should not extend beyond that provision in the face of the clear severability clause here. I see I'm out of time.
Any other questions?
I can wait for rebuttal.
I don't have any currently.
Thank you very much. Counsel?
Yes, hi, Your Honors. Good afternoon. May it please the court. The state in this case, as has been discussed, does not challenge the central conclusion of the preliminary injunction below. South Carolina's Senate Bill 1 would prohibit the vast majority of abortions in the state months before viability. And for this reason, it would flagrantly violate South Carolinians' federal constitutional rights. The state instead claims that the wrong people are in this court and that the scope of the district court's injunction at this preliminary stage was overbroad. Neither assertion is correct. First, As to this issue of third-party standing, it is bedrock law that litigants have third-party standing to challenge a statute that directly restricts their activities where enforcement of the challenge statute would violate the constitutional
Now, Mr. Miller is arguing that's not so in this case because there's he asserts an inherent conflict of interest between the healthcare provider and the patient in this case, who under this statute may be able to sue the healthcare provider so that their interests are potentially at odds. What's your response to that?
So, Your Honor, if I could make 3 responses to that. First, in June Medical Services v. Russo, the Supreme Court directly addressed the third-party standing of abortion providers, relying on, of course, decades of precedent before it, and found that third-party standing did apply in the circumstance that I just described. The court in that case said at page 2119 of the opinion, this is the plurality opinion, they addressed the suggestion that, quote, this case is different because the plaintiffs have challenged a law ostensibly enacted to protect the women whose rights they're asserting. Quote, that is a common feature of cases in which we found third-party standing. And that, of course, Chief Justice Roberts, in the 5th vote, joined that plurality opinion in full at footnote 4 of his concurrence. That is a binding precedent of the Supreme Court. It binds this court, and it directly refutes Mr. Mills' position as to a conflict of interest. Second,
so Mr. Mills is asking, Ms. Murray, Mr. Mills is asking us to overrule the Supreme Court.
Well, Your Honor, I would respectfully suggest that that is not within the power of this court. June Medical Services binds
That's what I'm talking about.
June Medical Services.
That's what I'm getting at. We don't have any power to overrule the Supreme Court.
You cannot do that. And the other thing that I would know with respect to this conflict argument is that, you know, the state in this case would have the court believe that this is the first abortion restriction ever where a legislature thought to put a private right of action into the additions to the abortion code. And that could not be further from the truth. I mean, for example, this court's decision in Stewart v. Kamnitz a few years ago about an ultrasound requirement in North Carolina, that had a private right of action to it. Planned Parenthood Central Missouri v. Danforth, 1976, that one, again, another abortion restriction, there was a potential for liability and damages. Gonzalez v. Carhart, another Supreme Court decision, 2007, the Supreme Court there actually, in the course of deciding whether the so-called partial birth abortion ban act could stand, referred to the fact that there was a provision in the act authorizing civil action. And they said of it, it is not of relevance here. I could go on, for example, the Planned Parenthood of Wisconsin v. Van Hollen case. The overarching point is that it is commonplace that states, in addition to state enforcement mechanisms, in many instances incorporate private rights of action. And were the state correct that simply doing so could somehow insulate the state's own enforcement authority from judicial review, it would be a dramatic reworking of the state of jurisprudence and would lead to, as Your Honor said, sort of overruling of the Supreme Court. That is not neither practiced nor condoned by precedent. I would also say, with respect to third-party standing, I know Mr. Mills cited a lot of case law. I heard him refer to a couple of cases, one called Stanley, I don't have it in front of me, and another, a Connecticut case. By my telling, those are not cited in the briefs, and so I would suggest respectfully that to the extent the court is going to consider something like that, a 28J letter or some opportunity for us to have a reasonable response, time to respond would be appropriate there. The other thing that I will say as to additional case law that he mentioned, he talked about Elk Grove, for example. Elk Grove was a case where the father who brought the claim on behalf of his daughter was found not to have standing, prudential standing, due to a potential conflict of interest because the child's mother and her sole legal representative had intervened in the case to dispute his ability to go forward on her behalf. And if this court, needs any further evidence that that case is not going to have the broad sweep that Mr. Mills suggests, you could look, for example, to Justice Rehnquist's concurrence in that case, where he talks about the narrowness of the opinion and suggests that it is precedent good for this day only. It does not affect this case, and certainly not in the face of the binding precedent that we have cited in our brief. The same would be true of Kowalski. Kowalski was a case where the traditional two-part third-party standing test the Supreme Court applied, looking both at a close relationship and whether there was a hindrance on the third party to bring their own claim. But of course, in this court, just a couple of years ago, in the Maryland shall issue case that we cited in our brief, this court looked at Kowalski, and it specifically said, it talked about the long line of precedent in which the Supreme Court has relaxed those two Kowalski standards, and pointed to cases like Craig v. Bourne and others that we rely on, where a party has been directly regulated by the challenge statute, and the enforcement of that law would violate third parties' constitutional rights. Beyond the issue of third party standing, I want to move on to the second issue that came up, whether 1983 provides a cause of action to plaintiffs who are proceeding as our clients here are here on behalf of third party standing. To Judge Harris's question about whether this came up in the district court, I think the answer to that is really no at the preliminary injunction stage. And I do read the court's motion to dismiss order in the same manner as Your Honor does, that what the court was holding, she acknowledged that the governor in that motion had brought both a third-party standing challenge and a challenge to whether Section 1983 provided a cause of action. I read her to have held, which is consistent with the cases we cite at page 33 of our brief, the Van Hollen case, the pediatric specialty case, that where someone has third-party standing, they, by extension, would have a cause of action under Section 1983. That is how I read her opinion. And to the extent that defendants were confused by that, they could, of course, have asked for clarification from the district court. They did not do so. And I would, again, as I mentioned, the Seventh and Eighth Circuits, I do think that it bears emphasis that what the defendants are asking this court to do would not only upend decades of practice, but would create a circuit split where there is no rational basis for doing so. And we would urge Your Honors to the extent that you reach this issue, to firmly reject the argument that has been put forward by the governor. Just one last point about that. I think Mr. Mills suggested that at page, or at docket 105 in the district court, we had effectively conceded that the preliminary injunction order somehow decided this 1983 cause of action. I think, again, consistent with what the district court actually said, our position is that where a litigant is proceeding in reliance on third-party prudential standing, that basis alone is sufficient to permit them to bring a cause of action under Section 1983, and that Section 1983 supplies that cause of action. So I don't think that there is certainly any concession or inconsistency in the position that we have maintained throughout the case. Third, and finally, I do want to address the severability issues that the state has raised. The district court here, in our view, correctly held that SB 1's other enforceable provisions could not be severed from the 6-week ban for purposes of the injunction. The district court faithfully applied severability law. So at pages 296 to 299 of its decision, it went through.
But Ms. Murray, didn't South Carolina have in place several of these other provisions before the heartbeat bill was passed? And if so, why couldn't they be severed if they were in place before the heartbeat bill, or something similar was in place before the heartbeat bill itself was passed?
So if I understand your question correctly, and correct me if
So
I
they
don't,
could stand separately because they have before.
But to be clear, at page 303, the scope of the court's preliminary injunction, she did not enjoin pre-existing statutory mandates.
Right, I understand that.
And so
just go ahead and explain to me how some of these things could not stand separately, how it's all intertwined.
Well, I think
the
that
ultrasound, for example.
Yes. So the district court, as I said, it recognized that it needed to look to the standard under state law, and as we talk about in our brief, that standard looks at whether the portions of the statute are wholly independent or mutually dependent on one another. In this case, the General Assembly adopted, the thrust of the Heartbeat Act is to ban abortion upon detection of cardiac activity. And so the portion of the ultrasound requirement, for example, that Your Honor is asking about, was adopted within the same section, Section 3 of the Act, in order to facilitate the enforcement and, essentially facilitate the action of the prohibition in the 6-week ban. So that heartbeat requirement has no medical purpose beyond facilitation of, well, it has no medical purpose, but the purpose in the statute is the facilitation of the ban. The same is true, for example, if you look at exceptions within Section 3. So Section 3 is actually it has multiple provisions in it. One of them is the mandatory heartbeat requirement, to attempt to detect a heartbeat. There are also exceptions that are incorporated into Section 3. And so the defendants, for example, would have you, I know Mr. Mills pointed specifically at what was incorporated at 44-41-680A, I believe he said. He would have you slice and dice up this law. And I think that the district court was correct in rejecting that argument when, if you look at other portions of Section 3, the heartbeat attempt to detect the heartbeat requirement, the requirement that doctors note whether a heartbeat was detected in the medical records, whether the requirement that the doctors in Section 4 report whether they've relied on exceptions to the heartbeat ban, all of those pieces of the statute work together to facilitate the ban. And I think certainly...
Counsel, it would help me. I'm really struggling with this severability thing, and I'm trying to figure out how much sort of your argument depends on purpose and how much depends on putting to one side purpose. Could these provisions operate independently? So let me ask you this question. If you took from Section 3, if you took just the requirement that before an abortion provider performs an abortion, you have to do the ultrasound, you have to do an ultrasound, and you put that together with the thing in Section 5 about, and if the ultrasound reveals a heartbeat, you have to tell the woman that, and whatever the associated statistics about the chances that that the woman will carry to term. If you cut and pasted this one section from Section 3 and Section 5, like that could operate independently as an informed consent statute, right?
Well, 2 points to that, Your Honor. As to your first question about how much we are relying on purpose, I think certainly under South Carolina law, purpose is a relevant consideration, but I don't think that this needs to be an entirely purpose-driven inquiry and shouldn't be under the governing South Carolina state law standard.
Okay, well, if it's not about purpose, why shouldn't we do the exercise I just did and say, let's sever those two provisions, slap them together, and now look, you have a new informed consent law?
Well, I mean, Candidly, Your Honor, I think your description in part shows why that wouldn't be proper. The idea that you would have to kind of cut and paste and move the statute around seems precisely like the kind of legislative work that the U.S. Supreme Court has said in cases like AI, the court should not be involved in. And it is incumbent on state legislatures to, you know, they can certainly say what they want about how the law should be enforced or severed, but they cannot push their work off onto the courts. And I think what you've described is precisely that scenario. As to your specific question, though, about the heartbeat requirement, the requirement to attempt to detect cardiac activity and then report that to the woman, I think we read that portion of the statute, again, to facilitate the ban. There is a requirement that once you detect a heartbeat, as in the words of the statute, you have to tell the patient that. But of course you do, because at that point, she is banned in the state of South Carolina from having an abortion. So I think in that context, the mandatory disclosure is in fact just a disclosure that the ban applies and is part and parcel of the portion of the statute that the district court held must be enjoined.
Can I ask you a question? If we did the cut and paste, and you would also, so that you put together the ultrasound requirement with informing the woman of the results, and saying some things about the statistical chances of carrying to term, would that be constitutional under Stewart? Is that kind of an informed consent provision constitutional in the Fourth Circuit?
Well, Your Honor, I think I do want to be clear. You know, I think it would depend on the particular statute. Our position is not that a state cannot require, you know, informed consent related mandates or require in some instances ultrasounds. That is not what we are arguing. We think it is a state, you know, it is a statute specific analysis under the particular state severability law issue. So I think to your question, could South Carolina have had its legislature taken its own pieces of the statute and cut and paste them together to create a different one? Could it have come up with something different that could have satisfied both constitutional review and have been severable? Maybe, probably, depending on how, you know, how they crafted the law. But what this court has before it is the law that they actually adopted. And I think that the district court was correct in not trying to step in with a red pen to try to come up with a replacement for a law that the legislature clearly crafted as a cohesive whole intended to ban abortion at the earliest stages of pregnancy in the state of South Carolina. So I think unless the court has any further questions, we would urge you to affirm the district court's preliminary injunction, which faithfully applied binding law and carefully held that SB1 is not severable. Thank you, Your Honors.
Thank you very much, Ms. Murray. We appreciate it. Mr. Mills, you reserved time.
Thank you, Your Honor. I'll start with severability. As Judge Harris suggested, there are two questions here: purpose and whether it's capable of independent operation. We know the purpose, the text says it. The legislature said it would have adopted each and every word of the statute. So the only question is independent operation.
Wait, what is the purpose?
It's that each and every provision go into effect. Every word not invalidated must go into effect. The Act says that expressly. So the only question is whether the other provisions.
What is the overarching purpose of the statute?
Right.
Well, it has multiple purposes, and the Act says it in Section 2. Part of it is to protect unborn life. Part of it is to give mothers enough information to make an adequate choice. The U.S. Supreme Court in Casey, page 882, said that helps mothers avoid devastating psychological consequences.
The South Carolina, can you hear me because you're talking and I'm talking?
I'm sorry, there's a delay, Your Honor.
Okay, the purpose of the statute, the title of the statute says South Carolina Fetal Heartbeat and Protection from Abortion Act. What does that mean, protection from abortion?
I would assume it means what it says, which is that part of the protection from abortion was the single challenge provision. Part of it was giving enough mothers enough information that some of them might choose not to have an abortion. Both ways are protection from abortion. So the only question.
Can I just ask you a question? I'm sorry, we were talking about the purpose of the statute, and I didn't understand. So you pointed to the last purpose, which is to help a pregnant woman make an informed choice about whether to continue a pregnancy based on the detection of a fetal heartbeat. But I don't understand that because there is no choice under this statute, right? Like, does that purpose almost sort of, is that like an alternative? Like, the statute can't have both purposes, banning all abortions once there's a heartbeat and helping a woman make an informed choice about whether to have an abortion if there's a heartbeat. So are these sort of like, is this almost contemplating that maybe one of the purposes will turn out to be unconstitutional? And that, like, how are these two purposes supposed to interact in your view?
Your Honor, I think it's not unusual for legislation to have multiple purposes. I think the severability clause expressly says what the General Assembly wanted to happen.
No.
This
is a genuine question, Counsel, and it would be very helpful for me. I understand your view. I understand what the severability clause says. This is just really a logic problem I am wrestling with. How can the same statute have as one purpose, which it clearly does, to prohibit abortion once there's a heartbeat, and as another purpose to help women make informed choices about whether to have an abortion after there's a heartbeat? They just seem logically inconsistent, right?
I don't think so, Your Honor, because the mother has a choice to make before the Act's prohibition goes into effect. And the Act is not an outright prohibition. The Act gives mothers in several circumstances the choice, even after a heartbeat, to still choose abortion. And so in those circumstances, of course, more information could be relevant to a mother's decision as to what to do in those circumstances. So I do think both.
I'm sorry, I just missed that. Say that again. So even though once there's a heartbeat, there can be no abortion, you still have, the woman might still want to know what the odds are that she would have carried to term?
No, Your Honor. In some circumstances, after there is a heartbeat, there can be an abortion still under this Act. And in those circumstances,
whether she wants to avail herself of an exception.
Correct, Your Honor. That would be one example. So consider what would have happened if the district court had only enjoined the challenge provision. Could the other provisions have taken effect? Of course they could have. They are in effect in numerous other states. They've been upheld by numerous other courts. As Judge Thacker suggests, Section 330 already requires this information be given to the mother. Now Section 740 gives the mother a private right of action. That the section already exists. Of course, it's capable of independent operation. Judge Harris?
I'm sorry. Go on. I may have misunderstood something you said. Go ahead.
The other side complains about surgical operation, but look at Marcellus, this court's decision, 972 F3rd 518, joined by Judge King, where it quotes Barr saying courts should be surgical when it comes to severability, and then expressly redlining particular words to rescue the rest of the statute. Here, the court doesn't need to do anything that severe. It just needs to say the other side only challenges one provision, especially on a preliminary injunction where they have the burden to show the likelihood of success and the other factors as to each and every provision. They haven't shown that at a minimum as the remainder of the statute. I see my time has expired. So unless there's other questions, I'd urge this court to reverse.
I actually did. So I am, with respect to severability, I do take the gist of your argument to be you can sever out from this statute like a kind of a heightened informed consent requirement. And I guess I would like to know, in your view, whether that it's clear that would be constitutional under Stewart. And I know your brief says informed consent provisions are often upheld, but we do have Stewart on the books in the Fourth Circuit. And I guess I would like to know your view as to whether it would obviously be constitutional if it were severed out, or whether the practical import of this would just be, now we're back in front of the district court seeking to enjoin the severed portion.
Thank you, Your Honor. I'd have two responses to that. First, the other side hasn't made any Stewart challenge, so that's waived. They have the burden of proof on preliminary injunction.
That's because they don't believe there is an informed consent provision in the statute. They think the whole thing is a 6-week ban, and that's what they're challenging. I don't think they're responsible for sort of challenging the part you think should be salvaged.
Well, Your Honor, they could have made multiple claims in their complaint. They could have attacked different parts of the statute. They chose not to.
They don't think they have independent operation. As far as they're concerned, this hypothetical informed consent statute we're talking about literally does not exist. You think it exists, and I'm trying to figure out whether I think it exists, and it would be helpful for me in answering that question to know whether, if I thought it existed, it would be constitutional.
And I'll address that shortly, Your Honor, but their complaint could have attacked the statute in the alternative. That's how complaints regularly are. So they could have said, even if there's an informed consent, that's not allowed under Stewart. They have the burden of proof. Even just now, the other side refused to make that argument, so they can't show a likelihood of success. But this case is different from Stewart because the big issue was that the woman had no choice. The images had to be described to the woman. Here, the law gives the woman the opportunity on whether she wants to view the ultrasound, and the law gives the woman the opportunity to hear her unborn child's heartbeat. That's the crucial distinction between this case and Stewart. So even if there had been a Stewart challenge, which there's
I'm
not.
sorry, I thought Section 5, under Section 5, it says the woman must be informed about the probable gestational age and, doesn't she have to be informed that a heartbeat has been detected and that to the best of the physician's knowledge of the statistical probability of bringing the human fetus to term? I thought that was stuff the woman has to be informed of.
That's correct, Your Honor, and I don't think that sort of factual disclosure was at issue in Stewart.
Okay,
Well, but,
so
all right, I thought I misunderstood too then, because I thought you just said that she's just given the opportunity to listen to the heartbeat and all that stuff, but she's required, not given the opportunity.
No, Your Honor, she's just given the opportunity to listen to the heartbeat and to view an ultrasound. The Section 5 provision is about purely factual information based on medical evidence of the likelihood of bringing the child to term based on the detection of the heartbeat. So it's not what was at issue in Stewart, which was having to see or hear about the ultrasound.
I mean, I agree that it's not factually identical. We just are in this interesting posture where in the Fourth Circuit, we apply strict scrutiny to this kind of the Fourth Circuit is in a somewhat different position than some other circuits, and so these informed consent provisions get a more careful look under Stewart, and I just had questions.
Yes, Your Honor, I agree that there might be a more interesting legal issue there had it been raised. It's not been raised, so it's not before this court. This court should reverse.
Mr. Mills, we've been very generous with you on the time. We appreciate your work. Ms. Murray, we appreciate your work. And we're sorry we're not in Richmond and where we could reach you personally. Maybe next time. We'll take the case under advisement, and Madam Clerk, we'll adjourn court until 8:30 tomorrow morning.
Yes,
Thank
sir.
you, everyone.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Hey,